Dismiss. May I please your lordship? Lordship, I beg to mention item number 26 of this. I have instructions to withdraw the.
Appearing for an all India limited. I will update to record my.
The 4 weeks. Okay, Mr. Ajida. Ajida, then office for the petitioner. Submit that he has received instructions to withdraw the writ petition. Mr. A.
Yes, sir.
Sharma appears for the All India Limited. According the writ petition is which as withdrawn.
Quickly, oblige.
May I please? So I beg to mention fully.
For listing.
Look.
Old matter, new matter.
No,
Old matter, new,
no.
pending matter.
Pending matter.
Very good.
Lordship, may I seek your indulgence to mention it online?
Yes.
So, Lordship, in today's list, there is a matter, Lordship. I'm told that there is some problem with the opposite side, Lordship. This is item 32. I'm told he's indisposed, Lordship. So he's hurt his arm or something.
Lordship, I am appearing on behalf of respondent number 1, Lord.
Okay.
So
So
therefore,
what happened?
Lord, actually, counsel for the respondent number 1 is bedridden due to fracture on her leg. I take up
How much time?
4 weeks.
4 weeks time.
I was thinking Lordship may fix it for January. If Lordship is indulgent to give a date, I will come personally to be physically present. 23rd January, 28th, 29th, whatever Lordship suits.
You're right. Adjournment prayer has been made on behalf of Mr. P. Kalita, current counsel for the respondent number 1, on the ground that he is bedridden.
Bed.
Mr.
MD.
Nalin Kohli, Lordship, appearing online.
Nayan Poli, senior counsel, appears for the petitioner.
Yes, Lordship.
Appears for the accordingly. Now, right on the prayer made by Mr. N. Poli and Mr.
MD.
M. Deka appearing on behalf of Mr. P. Kalita. List the matter on which date?
23rd January, Lordship, if it's convenient.
20. Huh? I know. The 23rd. 23rd January.
I'm so grateful. Deeply
Obliged.
obliged.
Baptist Wala. No, I back to mention item 36 of today's daily lake. Consent has been taken from the
Consent has been taken by from whom?
opposite part.
Opposite party?
Yes.
Writ petition, we usually call them what? Opposite party.
Responder.
What is your name?
DK Sinha.
You are appearing for
And Shah.
Mr. B.K. Sinha,
Sinha.
Singha,
Sinha.
appearing on behalf of Mr. N. Sharma,
Sure.
learned counsel for the petitioner.
Yes.
Praise for adjournment on what ground? Just,
So he's-
just like that.
Your Honor, he's actually, because of some personal difficulty, my son is which engaged with some family work to prepare.
And the adjournment on due to some personal difficulty. Well, he also submitted that he has taken the consent of the other side.
Yes.
Accordingly, leave this matter after
2 weeks.
2 weeks.
I do.
May I please allow? Lordship, with the consent of the other side, the document item number 9 and 10.
9 and 10.
We have just received the affidavit filed by them. So we
9
need-
and 10, you have received affidavit.
So we need instructions and file our reply.
Lordship, we are for the respondent to in item number 9, we have already filed our AI. And in item number 10, we are yet to file. Lordship, if it's 19,
Isn't it similar to serial number 1?
1, 9 and 10 are all correct.
it's all connected together on 19.
Okay, right. So you are appearing for in 9.
Yes, sir.
Mr.
D. Khan, appearing on behalf of M. Hazarika.
Mr. D. Khan appearing on behalf of Mr. Miss M. Hazarika, current counsel for the petitioner in WPC 6345 of 2024. Praise for
3 weeks time
3 weeks time to do what?
to file a reply.
To file reply.
Lordship, there is a stay operating. And for
Okay.
which
It is under a week's time.
19th,
In under a week's time to file. Today is what day?
there is the 12th, Lordship.
It is under a week's time.
Time
So,
to file.
Mr. Counsel, I'll release the stay. I will vacate the stay.
So, Lordship, any other day than 9.
Even 18, 20, 18 plus.
Your lordship, 21st.
21st will be the because we've engaged Chennai Council, the deputy judge, so you will not be.
20th,
20th.
20th, okay, Uh,
Motion day.
20th,
28th will be a motion.
so what? This is not a hearing, one.
19th will be more.
Hearing 19, he's having a problem, Mr. Council, we have to adjust.
20th.
He's granted a week's time to file reply affidavit to the affidavit filed by the
By the respondent number 1 to 4.
1 to 4. And this is the matter. On the prayer of the parties, this is the matter on 2011.
One day, modification.
Got number 9 and 10.
Interim order to continue. You just say, item 1, you say, list this matter. Along with WPC 3345 of 2024 and 568 of 2024 on 2011-2020. Interim order to continue till the next.
DPO.
Meet this, your lordship. I beg to mention a pending matter, my lord, it's a 2024 writ. Lord.
Date.
Matlab.
There is. Painting like.
Yeah. 38, 39, 40, 41. They're all the same. 8, I mean, they are all connected to item 11 to 19.
Yes.
All under 2019. So we can pick up all of them.
Yes, my lord, take
Now-
the matter along with the affidavit.
Now we can take it up now. Who's for the other side?
My lord, in my case, my lord, regarding the receipt of deposit of 1,41,000, my lord, they said that they have given a handwritten note that they have to deposit that much, but they have deposited on the same date. But they have not obtained a receipt, but they have went to the get this office right now, they are there. So they say they will take some time, they said they will issue a receipt for that. But they said that they have deposited on the same day. Because along with this.
And anyway, the problem is the PNRD is not here. That's the problem. He's informed, the entire court is waiting for him only. You give that, you said 11 to 19, you put in the puzzle. Oh, it's not.
Actually, what happened, my lord, the other AD is supposed to appear in this matter. Is report number 17. There are some matters are going on. So it will go may long. We are adjourning for the day.
No, you tell me one thing. First of all, have you filed affidavit?
Yes.
In which case?
Item number 14.
Give me item 14. Have you all got the affidavit?
Just now I have served to the petitioner.
Everyone has got? No,
Yes, sir.
there are a number of writ petitioners. Have you all got? Have you got? Why don't you give them copies?
I have served to all, my lord.
No,
I
Mr.
asked them also. I requested, my lord, to give their phone numbers so that I can.
You
Whoever,
please give the phone number to him.
I can serve right now.
Okay, so
My lord, 2 copies are extra there. I can serve right now.
now, okay, with now what to do? The AG is not present. But then you see, the problem is not the question is you make your modified NIT. That is not the problem. The problem is when will the process be completed? Will it take 1 year? Will it take 1 month? Will it take 20 years? We do not know.
Yes.
Because when this court had taken up the issue with the additional AG some time back, I think in July, the additional AG had given a categorical statement, which has been recorded in one of the orders, that it will be completed within a week.
Actually, my lord, he is also senior standing counsel in the Panchayat department. Therefore, my lord, in that week, my lord, the department prepared the model and submitted to the subcommittee of the cabinet.
Now you see the problem is
We are also hoping.
the entire process is going to take a long time. From the subcommittee, it will go to the cabinet will approve, then they have got to make amendment of the act.
I understand, my lordship.
That will take forever. Already not 5.
I can understand, my lord. I'm with the lordship thinking, my lord, but I just personally, my lord, I just want to learn an advocate general to appear, my lord. Thereafter, lordship may pass any order. I will accept.
When can he appear?
My lord, accept 22nd to 28th, lordship may accept. 22nd to 28th, he will not pay. November. 22nd to 28th is November. Next week, lordship can fix it. Yeah, or 29th.
We can fix it on 19th.
Yes, ma'am.
Is it okay? 19th.
My lord.
But what about his case?
My lord, his case is also similar, then there are other repetitions.
But my lord, I have there,
They
they have
don't have
deposited.
any
Huh?
They have
document
deposited.
show that he deposited before 29th.
But he was operating the market for two months.
There was miscommunication, ma'am,
No, my lord,
between
this
the
is not.
departments, madam.
My lord,
Okay.
I have the receipt of 3rd of
Where
July.
is that receipt?
But that's the first day when they deposit of 1,41,900 something rupees. They have received, they say that they have given on a note sheet and white paper, they write it that you have to deposit this much, they deposit it. But they have not.
Have you deposited by cash?
Yeah, they have deposited by cash.
My lord, it's an every time they will give a receipt, my lord, because they already annexed to
No, they have gone to the Panchayat office, my lord, they will.
Anyway, right. In all the matter, 11 to 19 and even to
item number.
38 to 41.
I'm repeating, my lord. 11 to
19,
19, 27, 28, 29, and 38, 39, 40,
the
40.
entire list is gone, that means.
38, 39, 40, 41.
Okay, right. Mr. S. Datta, appearing for the PNRD department, submits that the learned AG Assam will be appearing in this matter. However, as the learned AG is on his leg in another court, which will take most of the day, he pays for adjournment. On considering the submission made by Mr. S. Datta. And after taking the views of the counsel for the petitioners, it is agreed that the matter should be listed on 19, 19/11, 2024. Wait.
They may have the problem on that day, my lord.
Anything can happen.
Yes.
That will, on 19/11/2024, wherein an attempt can be made
Right.
to dispose of the matter.
Milord,
Highly obliged.
Milord, item number 39. And there is the extension order, Milord. I have private respondent is running the market.
On 19/11, this month is
Obliged, my
11 to 19, also in the other orders also, in the other thing. You just tag them or tag. Tag this case along with that item 11. Tag this case with item 11. Wherever those other 38, 39, 40, 41, those other.
And after the last hearing had taken place, my lord, I put my lord, I laid my hands on a decision of the apex court, defining the word turnover and giving meaning to it. My lord. This meaning,
Let us go one by one. Let us go one by one.
my lord, for assistance, my lord, I have called an officer.
Okay, no problem, no problem. We might need the help of the officer. Okay, the first one is 4258.
Which may directly come to page 47, the exemption clause on the
Page 47.
47. The exemption clause which I'm hopping upon, it's given there, my lord. Clause number 3.
No, let us see. The case here is that page 66 is the dear Chayanika
Yes.
handloom products, correct?
ITR not submitted.
Huh?
ITR not submitted.
ITR not submitted as per clause 13A. ITR, so income tax return,
Return. For
Okay.
a particular year.
whatever. So 13H. Correct, in
Yes.
terms of 13,
My lord is on Chayanika.
Chayanika, yes. So
Thing is, my lord,
just a minute. So your case is that
this is a turnover document
turnover. Yes.
and I'm exempted from submitting this ITR document.
According to you, the ITR is a turnover document, according to you.
And
Now, let us go to 3A.
3,
Where is that?
3B, my lord. 3B, itself,
3B.
page 47.
Yes.
This clause itself states that it's a turnover,
Let us see.
my lord. 3B. The average, page 47. my
Yes,
lord.
yes.
The average annual financial turnovers during the last 3 years, that is 2021, 21-22, and 22-23, could not be less than rupees 50 lakh. The audited certified balance sheet should be submitted along with IT returns for the years as stated.
So it says along with.
Along with ITR, so the audited certified
Fine.
balance sheet and the IT return are constituted to be turnover documents in terms of the clause of this tender document. Now, it is also settled provision of law that no one can, even the tender issuing authority cannot go beyond the clauses of the tender. Now, they have itself, they have themselves, in terms of clause B, understood the ITR document and the audited certified balance sheet to be turnover document. Now, can they, at this moment, decide that
No, if the ITR, it says ITR return filed for the year, if it is part of this 3B, then what was the requirement of there being a separate clause for IT return in 13H?
13 this particular clause 13 relates to what are the mandatory documents that are required to be submitted.
Correct.
This is the list given, my lord.
Correct.
So those who are not MSMEs, they are required to submit all these documents.
No, does not say that. This is different. 13 is different.
13 is
Let us go to 3E.
the,
Yes.
as per government policy circular dated so and so issued by Office Order Development Commissioner MSME, Ministry of Micro, Small and Medium Enterprises, Government of India, micro and small enterprises, MSEs are exempted from prior turnover and experience in all public procurement subject to meeting of quality and technical specifications. The bidders need to submit the up-to-date copy of the certificate of registration of micro or small enterprises to them registration certificate issued by the Ministry of Micro, Small and Medium. Government of
Where is this government circular? This 2016 10th March.
that has not been
By you. That has not been, this is your interpretation.
this document I do not have. My lord, this is section we have.
We have an,
We have in our
Yeah.
affidavit.
right?
My lord, the affidavit filed by record number 2, my lord. This is serial number. This is annexed A, my lord.
Annexure A.
Annexed A.
Okay, yes.
This-
No, annexure A, no, annexure is different. Annexure is, it's,
Office memorandum, my lord.
office matter dated 29 2016. I am asking for
Yes, my lord.
government policy circular dated 10th March.
10-3.
Anyway, both of you have not put it. Anyway. Let us see.
That is available online, my lord. I can submit it after some time. I'll furnish it.
Just a minute, let me see. Schedule of requirement. Now you see, come to page 54 of your interpretation.
54. Yes. 13.
What does it say? Technical bit part 1. Just read.
Following self-attested documents in hard copies and in online must be submitted in technical bit. Without this, the tenders will be rejected. So these documents are required to be submitted. Now, my submission is, my lord, since I'm an MSc, my lord, the documents related to turnover, which are enlisted in this particular clause, those, my lord, in case of MSc, they are exempted from submitting those documents.
So according to you,
Not
Yeah,
all, not all these
just a minute, Mr. Counsel. When you look at CE says
three.
MSCs are exempted from prior turnover and experience. Now, according to you, this turnover document will include a ITR.
ITR,
That is his task. That is his
Fine,
work.
fine.
Nothing ahead.
No.
That is
three documents are put for turnover according to subsidiary law. My submission is, my lord, number one is ITR. Number one is ITR in terms of clause 3B.
just a minute. So according to you,
Three documents are proof of turn,
three documents
are proof of turn.
are proof of turnover.
Number one is the ITR.
Number one is ITR.
ITR, my lord, that is my
Okay.
submission.
And then
And-
number two is
And definitely the audited certified balance sheet.
audited certified
balance sheet.
balance sheet.
I'll place a judgment to that regard, my lord. And
Yes.
the document at 13I, my lord. It cannot be more obvious. 13I, lordship may see, page 54,
Document in clause 39.
39. It's obvious, my, cannot be more obvious. It itself says it's the turnover term. 39, page 40, definitely. 39, may I read, my lord?
Yes, sir. Yes,
The certificate from registered chartered accountant or statutory authority indicating annual financial turnover during the last 3 years should be furnished with UTI. So definitely 39, there cannot be any doubt, my lord, that this is the turnover. So my case is, if any of the petitioner's case have been rejected, my lord, based on these three documents, then I come in. Otherwise, that is my. So one by one, I'll show, my lord, based on which document, my lord, the cases have been. Choyanica has been rejected for non-submission of ITR for one particular year.
first of all, why is this page 47? Why is it not complete, this 3B?
3B, my lord, I have furnished a legible copy, my lord. That is why I indicated on the earlier occasion that lordship may take up the next.
Show me, no, show me.
My lord, additional affidavit I have filed, I have given a legible, more legible. That-
Additional affidavit you have filed where? In which case? There is no additional affidavit here.
Hand over my copy.
Your copy might have been, unfortunately, the court copy
And
does not have any additional affidavit.
in the next case, my lord,
Does
the
it
cop-
mean reply affidavit or what?
no, my lord, an additional affidavit. The other case, next case, my lord, page 40, it's totally legible. The book is
Yes, okay.
3C is also an exemption clause. It is exemption for the purpose of having.
That is, this is basically experience. So, yes,
So now, if you
so
are
your case is basically that the ITR is also pertains to annual turnover.
turnover, my lord, the reason, if I may submit, my lord, why they have included the IPR, my lord, in clause 3B. There's a reason, my lord. Definitely the audited balance sheet, my lord, which shows the profit and loss account, it's a turnover document. Now, it's a certificate, my lord, the document given by the chartered account. Maybe, my lord, the figures can be manipulated out there. But the ITR, being a statutory document filed before the statutory authorities, there cannot be any manipulation. So to cross-check the entries, that is why they have mandated that. That is my submission.
Is there a difference between an ITR and an annual turnover document?
Well, the annual turnover document has not been defined anywhere, but the Supreme Court in a judgment, if I'm allowed, please with your lordship, my lord, has given a kind meaning to that, my lord. The short judgment, if I short is paragraph, my lord, paragraph. It will make clear, my lord, what is turnover. Page 8, paragraph 19 on.
Page
8, paragraph 19 to 25 is there.
paragraph 19 and
19 to 25, short paragraph. There it. There it.
this
Paragraph 19. Normally, the term turnover would show the sale effected by a business unit. It may happen that in the course of the business, in addition to normal sales, the business unit may also sell some other things. For example, an SSE who is manufacturing and selling stainless steel utensils, in addition to steel utensils, the SSE might also sell some other things like an old air conditioner or old furniture or something which has outlived its utility. When such things are disposed of, the question would be whether the sale proceeds of such things would be included in the turnover. Similarly, in the process of manufacturing utensils, there would be some scrap of stainless steel materials which cannot be used for manufacturing utensils. Such small pieces of stainless steel would be sold as scrap. Here also the question is whether sale proceeds of such scrap can be included in the term sales when it is to be reflected in the profit and loss account. In ordinary accounting parlance, as approved by all accountants and auditors, the term sales, when reflected in the profit and loss account, would indicate sale proceeds from sale of the articles or things in which the business unit is dealing. When some other things like old furniture or a capital asset in which the business unit is not dealing are sold, the sale proceeds therefrom would not be included in the sales, but it would be shown separately. In simple words, the word turnover would mean only the amount of sale proceeds received in respect of the goods in which an SSE is dealing in. For example, if a manufacturer and seller of air conditioners is asked to declare his turnover, the answer given by him would show the sale proceeds of air conditioners during a particular accounting year. You would not include the amount received, if any, from the sale of scrap of metal pieces, or sale proceeds of old or useless things sold during the accounting year. This clearly denotes that ordinarily a businessman by word turnover would mean the sale proceeds of the goods sold by him. So far as the scrap is concerned, the sale proceeds from the scrap may either be shown separately in the profit and loss account or may be deducted from the amount spent by the manufacturing unit of the raw material, which is steel in case of the respondent SSE, as the respondent SSE is using stainless steel as raw material from which utensils are manufactured. The raw material which is not capable of being used for manufacturing utensils will have to be either sold as scrap or might have to be recycled in the form of sheets of stainless steel if the manufacturing unit is also having its re-rolling plan. If it is not having such a plan, the manufacturer would dispose of the scrap of steel to someone who would recycle the said scrap into steel so that the said steel can be reused. When such scrap is sold, in our opinion, the sale proceeds of the scrap cannot be included in the term turnover for the reason that the respondent unit is engaged primarily in the manufacturing and selling of steel utensils and not scrap of steel. Therefore, the sale proceeds of such scrap would not be included in sales in the profit and loss account of the respondent. This line assumes significance. Turnover basically means the sale, total receipt from the
The
sale.
buying and selling of that
But-
article.
And those are included, and those figures are included in the profit and loss
So-
account. That is
What
basically.
is the difference between turnover and income tax return?
Income tax return, my lord, in the income tax return, the total, Taxable income.
Is the turnover mentioned?
Yeah.
Is the turnover of a business mentioned in an income tax return?
in the assessment form, acknowledgement form, it is not mentioned, but in the,
If it is not mentioned, then how can it be said to be a turnover certificate?
that submission I have made only because of the stipulations contained in clause 3B. They have understood in that, that is one, that is
That is your interpretation.
That is my interpretation. So far as the IPS document is concerned. But my lord, 13H and 39, that profit and loss account, that is definitely my lord in terms of the statement. And 39, the clause itself is that
Okay, that we're not interested. We're not interested in 39. Your bid has been rejected on the ground of 13H.
13H, ITR, my lord.
Yes.
And, but the other two cases, my lord, it's based on 39.
That is, we'll see. That's why I'm saying one case at a time.
So, so
This case, though, I don't think you have much of a case. Prima facie.
and two more, and this my
Yes,
just
yes, yes, yes. Carry on.
paragraph 24, the situation would be different in the case of the buyer who purchases scrap from the respondent SSE and sells it to someone else. The sale proceeds for such a buyer would be termed as turnover for a simple reason that the buyer of the scrap is a person who is primarily dealing in scrap. In the case on hand, as the respondent SSE is not primarily dealing in scrap, but is a manufacturer of stainless steel utensils, only sale proceeds from sale of utensils would be treated as his turnover. The last paragraph, which I'm relying on, paragraph 25. So as to be more accurate about the word turnover, one can either refer to dictionaries or to materials which are published by the bodies of accountants. The Institute of Chartered Accountants of India has published some material under the head Guidance Note on Tax Audit under Section 44AB of the Income Tax Act. The said material has been published so as to guide the members of the ICAI. In our opinion, when a recognized body of accountants, after due deliberation and consideration, publishes certain materials for its members, one can rely upon the same. Para 5 of the said note deals with sales, turnovers, and gross reserve. Para 5.2 and 5.3 of the said notes are reproduced herein below, which pertain to the term turnover. Para 5.2, in the guidance note on terms used in financial statements published by the ICAI, the expression sales turnover item so and so has been defined as the aggregate amount for which sales are effected or services rendered by an enterprise. The term gross turnover and net turnover are sometimes used to distinguish the sales aggregate before and after deduction of returns and trade discount. The Guide to Company Audit issued by ICAI in the year 1980, while discussing sales, stated as follows. Total turnover, that is the aggregate amount for which sales are affected by the company, giving the amount of sales in respect of each class of goods dealt with by the company and indicating the quantities of such sales for each class separately. Note, the term turnover would mean the total sales after deducting therefrom goods returned, price adjustments, trade discounts, and cancellation of bills for the period of audit, if any. Adjustments which do not relate to turnover should not be made. Example, writing of bad debts, royalty, where excise duty is included in turnover, the corresponding amount should be distinctly shown as a debit item in the profit and loss account. Therefore, the aforesaid meaning given by the ICAI clearly denotes that in the normal accounting parlance, the word turnover would mean total sales as explained herein above. Hello, this judgment in the respective subject gives meaning to the word turnover. Means, my lord, the total sales.
I agree.
And-
It gives meaning to the word turnover. There's no quarrel with that.
And
The
whatever
only issue is whether that will include within its ambit.
the idea.
Okay.
That is, so far as Janaka is concerned, I have made this submission because the tender in issuing.
This judgment, no one has a quarrel with it. It is all, it is, I mean, this is the Supreme Court saying that what is the turnover? No problem with that. Only thing is that this judgment does not say that turnover will include ITR.
Definitely, my lord. That is my submission with regard to Choyanika's case. Only because of the fact that clause 3B of the tender document says that these two documents are required to be submitted so far as turnover is concerned. So my submission is that the tender issuing authority have themselves understood the ITR document and the turnover document. So at this point of time, they cannot reside back from the court. With regard to Choyanika, that is my submission.
Okay, let me hear.
My lord will come to page 54
54,
of the report.
more of the report.
Where that 13H is there, my lord, that page.
Yes.
My lord, in the very instance, my lord, in top, technical bit part 1, it's written here.
Yes.
My lord will just appreciate one thing. Following shall cut off the document in hard copy and in online must be submitted in technical bit
without these standards will be rejected. Meaning thereby, my lord, these are mandatory documents.
Correct.
There is no ambiguity, my lord.
Correct.
In words, these are, my lord, document mandatory for the bidders to, and if they want to, my lord, avail any my lord, exception, my lord, on this document, either they have to approach the authority or they should have, my lord, earlier come to the before this honorable court challenging this.
Yeah.
Either of the cases that it will do so. Now, my lord, I'm coming to 13(8), by which, my lord, we have, my lord, rejected, my lord. Copy of the income tax return and annual audited, my lord, annual audited balance sheet and profit and loss account for the last 3 years, 2020, 21, 21, 22, 22, 23, duly certified by a chartered accountant. My lord, here they did not file ITR.
They did not file it. Did they submit this annual audited report? Annual audited report is submitted.
My lord, here they have failed ITR for financial year 22, 23 not found, but balance sheet and profit and loss account found. That is what, my lord, we indicated in the, my lord, our compilation. So now, my lord, Now, my lord,
the reason for disqualification
yes, my lord.
has been clearly spelled out in page, where is that? In page. Yes, petition council, where is that?
My lord,
13(8), my lord, in
Indian
Page,
Act-
page,
66, my lord,
page 66.
Yes.
It is ITR not submitted.
not submitted as per clause 13.
Ah, that-
So now, my lord, if I just read, my lord, what is ITR, Income Tax Act, my lord, what it really means, my lord. I just, when my lord was deliberating, my lord, even I also wanted to enlighten myself, my lord. Income tax return,
I thought you already knew.
I knew, my lord, but still, I left that page, my lord. So again, I'm reading from here, my lord. Income tax return is a form in which SSC file information about his or income and tax thereof to income tax department under various clauses, my lord. The Income Tax Act 1961 and the Income Tax Rule 1962 obligate citizen to file return with the Income Tax Department at the end of every financial year. These returns should be filed before the specified due date. Every income tax return form is applicable to a certain section of SSC. Only these forms, those forms which are filled by the eligible SSC are processed by the Income Tax Department of India. It is therefore imperative to know which particular form is appropriate in each case. So basically, my lord, this is not exactly, my lord, turnover, my lord. Every citizen, my lord, those who have income, my lord, apart from those who are exempted by Income Tax Department, my lord. They like, my lord, Mizoram, Nagaland, Meghalaya, my lord, being part of Manipur, my lord. These particular regions are, my lord, basically they are exempt from income tax. So they may not, my lord, file this. But other, my lord, even a person of, my lord, is
You see, you just have to tell me the difference between the ITR and the annual turnover. That's all.
annual turnover is, my lord, the gross income from a sale of goods of an individual or an entity, business entity, where income tax return, my lord, is an assessment made by the Income Tax
See.
Department on which tax is, my lord, calculated. These two are, and my lord,
Anything in support of your submission.
regarding, my lord,
And otherwise you have to give me your phone.
no, man. Today, my lord, before the day ends, my lord, I will give my lord, the document. I will get the document, my lord. and
Okay,
I'll-
anything else then?
So, my lord, basically this, and second thing, my lord, while submitting, my lord, this is the document that, my lord, he has submitted 2 years.
Huh?
ITR, only he did not submit for 1 year. He has submitted for 2 years.
Okay, ITR submitted for which years?
My lord, he only did not submit for 22 and 23. But he has submitted for
Submitted for 2020,
21, 21, 20, 21, 22. Meaning thereby,
2021 and 21, 22.
22 he has submitted.
21 and 2020, 22 and 22 he submitted,
And 22,
not
23,
not submitted. For
22, 20.
22, 23. And what is the what is the requirement of this
My lord, 2021,
13 for 3 years?
3 years. So my lord, he has submitted for 2 years. He fell short, my lord. It is not that he's got an exemption. He did not, my lord. My lord, he contested, he did not have the document, and there he fell short. So
Okay.
my lord, now he cannot take a turn around and now say that we are exempted. So once he has taken, my lord, that call, we have to assess him by that only, my lord.
So your case is twofold. One is turnover and ITR are different.
Yes.
Number 2, he did not submit the 22, 23 turnover.
Turnover. But other 2 years he submitted. So now he cannot, my lord, make a turn around, my lord, that seeking exemption. He did not seek exemption then.
There's no question. No, the question is this. The question is whether 3E will exempt the filing of a ITR.
Right.
That is your question. And according to you, it is
The turnover document, that's my submission based on 3B, the stipulations contained in 3B. Because the tender issuing authority has understood it in that sense.
My lord, in this regard, my lord, I am just facing, my lord, the compilation sheet, my lord, where we noted that he did not, my lord. I have marked it in.
no, that is he's accepting. He's not denying. He's not denying. He's not denying.
Then I have no
So,
more
so
further.
this matter finished.
This is finished.
I'm admitting
Okay.
22, 23 also.
Huh?
I've admitted 22, 23, I cannot submit.
Okay, so this item finished. So we will judgment reserve. Now let us go to the next. Next,
Jai Booking. My respectful submission, my lord. That's not-
where is it page?
Page 48,
Page 48.
there cannot be more
No, I'm the rejection.
rejection is there. Page
Page
50.
72.
Just a minute. Page 68 and 69.
Baki, 69.
69. That's serial number 12, Lordship.
Document submitted but not in conformity with 13I.
39, page 55, my lord. It's an obvious.
We'll have to, just a
Page 55, 13. Certificate from registered chartered accountant or statutory authority indicating annual financial. So it is definitely a kind of turnover.
page.
55, 39.
Certificate from registered chartered accountant statutory indicating annual financial turnover.
Definitely a turnover document. And it's the only document for which
Yes,
there was some mismatch in the hard copy and online copy.
that is a difference.
No, I'm coming there, my lord.
You get
My lord, what happened? While compilation, my lord, we have found that as per UDN verification in ICAI portal, data mismatch with CA certificate.
But that is not your case at page 68.
Yes,
At page 68,
yes, ma'am.
you have basically said
Yes.
that document submitted but not in conformity as per 13I.
Exactly, my lord. Document submitted but not in conformity with 39.
Okay, what was the,
This certificate from registered chartered accountant territory auditor indicating annual financial turnover during the last 3 years should be furnished with UDIN number.
no, that is, okay, that is as per, yes, as per you,
That is the clause, my lord.
as, where is that?
My lord, page 55.
Yes.
Page 55, 13I.
Yes. Yes,
is the clause, my lord.
within number, yes.
Yes. Now, my lord, whatever, when we have looked into it, my lord, what we found is that as per UDN verification in ICAI portal, my lord. So we go to the portal, my lord, what number they have given. We have gone to the portal,
You going into the portal, which portal?
it's ICAI, my lord.
I see,
ICAI,
yes,
that is the Indian Chartered Accountant, my lord. That portal, my lord.
yes.
Tata mismatch we have found. Then we have gone into it, and then, my lord, we have found that
of the last 3 years, we have submitted it from 18 to 19 members. And in
the
the
years that we just submit.
So they submitted 2018,
19,
19, 20,
21.
20,
In the online.
20, 21.
My lord, now this is the, my lord, this is what they have done. While submitting, they have given us 18, 19, 19, 20, 20, 21, 21, 22, 22, 23.
21, 22,
In the-
22,
my lord,
23.
Online, they have given by CA, they have certified. When we verified this, we found that it is not true.
Not true.
Not true, my lord. We have found that they have done about 21 in the portal. But this is a document, what CA has certified, my lord, I would say it's incorrect.
So you mean there are two documents?
Two documents, my lord. What we have found in the portal, my lord, that is they have up to 21, but they have certified that he has up to 23. Whereas, my lord, in the portal, it is not there.
May I clarify? In the portal, the document which I have uploaded contains the data from 2018 to 21 for
Correct.
3 years.
Correct.
But in terms of the tender document, I am required to submit it for the last 3 years, 20 to 23. Malak, the online document which I had submitted to the previous document, which I had mistakenly uploaded. But while
So that's why I'm asking you, do you have two documents?
yes,
Where is those two documents?
the second one is at page 72 of the petition. I have an on hard copy. While submitting the hard copy, I have submitted the correct one. Now, assuming there is a mistake in terms of 39 being a turnover document, I'm exempted from submitting this. That's my case.
My lord, while they have submitted online, they have submitted a different document.
No, but you see, one thing you've got to also understand that he made a mistake. And even if he did, supposing he did not submit. Okay, there are two ways of looking at it. One way is that though he was not required to submit, he submitted. And which was not in terms of the contract. So since he has now submitted his document will have to be scrutinized. Please understand what I'm
Yes,
I'm
yes,
trying to
yes,
explain something to you.
Yes, well,
Whatever I said.
my lord, regarding that, he was not supposed to, my lord, he has an exemption on this document,
Ah.
until he submitted.
So
My lord, I was just trying,
so what did I say after that? Please try to understand.
My-
For me to try to understand your case,
My-
you have got to understand the queries that I am putting to you,
My-
or the way this court should think about the case. You want it to be decided in one way,
my,
and you've got to convince me that way. So wherever I have got some doubt, you've got to clarify.
sorry, my lord, I will.
So the issue is this. Now he is exempt from submitting turnover documents.
Right.
He is supposed to submit documents from 2020 to 23. He submitted documents from 18 to 21 by mistake, though he was not required to submit. Now, one way of looking at it is, since he is not required to submit the document, but since he has submitted anyway, then those documents will have to be subject to scrutiny. because he submitted it, though he was exempt. It's like being given a concession but not taking the concession. And so he'll have to be scrutinized. On the other hand, there is another way of looking at it, is that he might have submitted the wrong document, though he had the right one. But and because he was exempt because of 2(3)(e), the submission of wrong document does not cause any prejudice to the petition or to you.
One second, I will just, one second.
So what do you understand by that?
My lord, that is not actually a wrong document, my lord. That is what I wanted to clarify, my lord. My lord, when we have gone to the portal, my lord, and we check, is this 21, 20 to 23 was,
He has not understand the question.
no, my lord. He has submitted not incorrect, that was not, we would say it's a false document. That is what I'm trying to indicate, my lord. He has submitted. But when we check this in the portal, it was not there. Meaning thereby, my lord, they did not generate. The portal, original portal, it's like, my lord, just in my, our language, my lord. Suppose I communicated to my client that yes, this order has been passed. And when he checked into our website, that matter was never listed on that date, or maybe no order was passed. It is like that, my lord. My lord, here, when we have gone into the portal, my lord, in the website, and we have checked by their ID, their particulars was till 2021 was there. Then from 22, 23, it was not there.
Correct. So that is what he's saying.
But he has submitted.
Correct.
He wrote that,
He has submitted a wrong document, though he was not required to submit.
my lord, no, my lord, that was like, my lord, misleading us. He did not, my lord, have that certificate, but he got that document. He claimed that he has that. That is the problem, my lord.
So where is that? Where is this document? Do you have it?
Oh.
Can you have this?
Let him like this, my lord, from the portal, my lord. I see a
Do
portal.
you have this document?
This is up to 20 and 21. And my lord,
Where is
come to
this
page number 72, what he is claiming?
Both
72.
72 is his writ petition, my lord.
is kindly confused, my lord. Okay.
No.
That you can also try. So it will be
My lord, come to page
so
number
that
72.
so that I can decide in one of your favor.
My lord will come to the bottom, my lord. In the portal, it is 2021, my lord.
Yes.
And now, my lord, page number 72, my lord, you will see.
These are two different documents.
That is what he's saying. He's saying that he's got two documents. One document, he has uploaded the wrong document which he was not supposed to upload. That's what he's saying. I want to see when this documents were issued. What is the date? What is 9623? And when is this document issued?
My lord will come to page number 72.
Yes.
72, my lord. This is a CS, my lord, certificate, where it is claimed that in 22-23, his, my lord, turnover was this 74 lakhs something, my lord.
Yes.
But, my lord,
And this document that you have submitted now, you have shown,
my lord,
this was issued when?
no, my lord,
Prior to 9623.
my lord, I will
It
find
was-
the date is there.
That is the.
It says there verification date time 6/2/24 cannot be. Then the Udin generation date time 24/1/24.
So, my lord,
Date of signing of document 24/1/24.
Was submitted along with the tender.
and-
So it will be 21. That's it.
and-
No, okay, it says 24/1/24. Date of signing.
What?
Signing by who?
By the chartered accountant.
So you have got
he has submitted in
you have got a document for 5 years signed in 23,
23.
and you have got a document signed for 3 years earlier period of time signed in 24.
It was a mistake, man. Well, wrong, we have uploaded the wrong document. That is our case. Subsequently, while submitting the hard copies, I have submitted the correct document. But thing here is, since it's a turnover,
When was the last date of submission of the tender?
eh, 11,
My lord, this is the document we got, not the
1/2/24.
Huh?
1/2/24.
1/2/24 is the last date of submission of tender. So what?
My lord, this document, my lord, in page 72, my lord will find the date is 9/6/23.
Correct.
And that document, my lord, which is before your lordship, my lord, while verifying, we got this document, my lord. That is the signing document.
Let me take my lord.
So my lord, meaning thereby, he never had this 22/23, but he has tried to mislead us by this PS certificate. Only on verification, we found that, my lord, he does not have this document.
Even assuming I don't have a turnover, my lord, they cannot reject my case. Being exempted.
My lord,
No, but then, look, there are, like I said, there are two aspects. One is you are exempt. Though being exempt, you still submitted the document, which now does not match your original. You're giving reasons saying that it is a mistake. Now, according to them, it's not a mistake, whatever. Now, there's another way of looking at it. Though being given exemption not to submit documents, you submitted the document. Once you submitted the document, wouldn't your document be subject to the same scrutiny as is given to the document submitted by the other bidders?
Lord,
No, just answer that. But now, how should this court approach the issue? Whether the filing of a document which was not required to be filed would now require the authorities to scrutinize the document as is being scrutinized with regard to documents submitted by the other bidders.
so the same standard has to be applied to all.
So that will be
Now,
applied to all.
the bidders who have been technically qualified, my lord, same mistake appears in their documents also, but they have been technically. I'll show my that exempted
my
document.
lord, I have all the documents.
I'll show from that.
Okay, with regard, now let us see. In this case, this particular case. Now, is it the private respondent is there
Yes, my lord.
for our respondent number? Now you show me which of these private respondents in this case, whether his bid was also not in conformity with 13I.
39.
13P and
39.
39, my lord.
39. You
But-
cannot go into other issues.
exempt.
You see, it has to be on the same issue, 39. You are on 30, your bid has been disqualified on 39.
39.
Show me on 39 whether.
We can agree. When they have
So, okay, so one submission is, according to you, private respondent have all qualified in
Not
respect
all
of 39, in respect of clause 39. Correct? 13I.
9 and 10.
They have all qualified in respect of 39. There are only 2 respondents,
No,
private respondents,
uh,
10 respondents. So all of them, so their bids have all are all in consonance with 39.
39 days.
They are
In that case, now, but they are not in consonance with other clauses.
Exempted clauses and mandatory.
Okay, not in consonance with other mandatory clause.
As well as exempted.
Exempted. But it does not touch upon 39.
Cannot mislead down. What is the fact is the fact. I'll never.
Then how is it? It's so
What?
difficult then.
My submission is in terms of 13I. I was not even required to submit it, submit the,
Correct.
Yes.
I agree, but you submitted.
I submitted as a measure of abandoned caution.
You have submitted. Now, can you say that once you have submitted, your document should not be subject to scrutiny?
Yes, they can scrutinize, but they cannot, my lord, reject my case on that basis because it was an exempted document. That is my submission. Because the same thing.
It's like saying this. It's like saying you can apply for the chokidar post, but you have to be a class 10 pass. But if you are a tribal, no need of submitting your proof of passing class 10. So this tribal person, he anyway gives a certificate, and it is found that his certificate does not show that he passed class 10, passed only class 9. So what will the authorities do? They'll have to ignore that document or not?
But in my respective submission, they will ignore.
They have to ignore because exemption is being given.
And one more thing, my lord, in both the certificates, it's not their case that the figures are, my lord, manipulated figures. These are genuine figures.
No, the thing is this, once you submitted a document, though you're not required to submit, so why should it be now not scrutinized? Why should it be discarded?
We verified that.
I know.
That is my submission, my.
No, I'm just asking, I'm trying to find a way out. Is there some way,
My submission.
some citation or something to the effect that even if you are exempt, you had submitted the document and that submission of the document should not be should not be a deciding factor in whether you should be considered fit or not fit.
That's what,
Slightly difficult to
that's
take it.
because once,
I understand your case, but that is a problem.
once exempted, my lord. And it's not the case of the respondent authorities that these are not genuine documents. These are genuine documents.
The problem is you have not been able to show this court today that your uploaded document is there with you.
That,
That those three.
that he has submitted, my. That is the uploaded document. I'm not disputing.
No, sorry. This is just
Verify.
an uploaded document. Where is your genuine or original document?
No.
Where is it signed?
They never,
Where is it signed by the chartered accountant? It is not signed.
It's a digital document.
Correct,
Yes, it's a digital
Correct.
document. Physical signature would not.
correct. So where is the physical document?
There, in case of UTI and certificate, my lord, there won't be a physical document. It will be online.
No, you see, this uploaded document is on the basis of a physical document.
No, it is generated
It-
online.
No, this is generated online. And your page 72 is not generated online.
Lord, you see,
If this is generated online, your page 72 is not generated online.
definitely I can have a copy. Definitely,
Now you're,
and my lord, I just want to add
wait,
one
just a minute.
I can have a print out, my. There is no problem. But at this moment, I'm not having. If logic gives me time, my lord, at 2, I can definitely furnish what I have submitted. To get a print out of it. At 2, I hand it over to the court now. So if it's available online, you can get it downloaded, my lord. I hand it over to the owner.
It's again, you're saying that all these documents are generated online. Your page 72 is not generated online.
I'll hand it over, my lord, to the court.
and my lord,
Anything else?
just one thing, my lord. My friend has submitted that as a matter of caution, my lord, he has submitted this document. Though he is exempted. My lord, I would rather say no, my lord. As a my lord, matter of caution, my lord, they have try to make it sure that they have this document to show us and just to my lord mislead us that they have the document of 2023. That is why my lord, he has certified this document. My lord, I don't want to say this is a manufacturing document, but my lord, we took it as my lord that this is somehow how they have misled us. And that is why, my lord, we investigated and we got this document from online and we saw that no, it doesn't have this document and this doesn't tell it. That is why dispatch, my lord. I don't want to be my lord any What any, use any harsh
I can also. use
word, my lord, my lord.
No, no, none of you all have been very soft to each other and very polite and cordial to each other. Why should you be hard and hard on each other?
that.
No, it doesn't help anybody.
My lord.
Okay, this is also judgment reserve. Put this in the other one.
Yeah, complete.
Give it, yeah.
Empty.
What is the next?
Empty space.
NPS, okay. 432. Okay. Yes,
In this case, my lord, 13H and 39, the balance sheet and
no, let us see, let us take the rejection.
rejection is at page
Page number 69, my lord.
68, 69.
69 is precise, my lord. Serial number 21.
68, 69. NPS, okay.
Yep.
Within number C is not distinct.
Two, my lord, two grounds, my lord. First is document not submitted for financial year 22-23, as per clause 13H.
What is the document, my lord? Balance sheet, which is the turnover.
My lord, balance sheet, profit and loss account and turnover for financial year 2023, not subsequent.
Thirteen H.
13. My lord, here it is not distinct again. This page 56.
Distinct can always be clarified. Not distinct.
No, 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 my lord. I'm talking about this writ petition. In page 56, the 13H, that was it, not
This
distinct.
page,
13H is
Sorry, 13H.
13H is clear.
Yes, my lord, that part, I understand, my lord, that one clause that not distinct, but the other part, my lord, a copy of the balance sheet, profit and loss account of last 3 years, my lord. These are, my lord, mandatory documents. These did not take exemption. correctly. He submitted for 2 years, one he put up.
The turnover document for in terms of the technique.
It is a turnover document. One thing, so it's a turnover document.
Profit and loss account, my lord.
Actually, profit and loss will be turnover.
Balance sheet, profit and loss account of last 3 years. my lord.
Will it be turnover? Will the annual audited report balance sheet profit and loss account of last 3 financial years duly certified by SCA, why can't it be a turnover document?
My lord.
That is the turnover.
My lord. But my lord, here the thing is that, my lord, he has contested, my lord. He has
Submitted
submitted 2 years.
2 years. He
2 years,
submitted only 2 years.
2 years. Well, the requirement is 3 years.
No, so you see, out there slightly different. Out there, so he had submitted, he did not,
Income tax return. First is income tax return.
income tax return is different. Income tax return, so it's quite clear. The second one and this one slightly interconnected.
Little there is a,
They are slightly connected.
but my lord,
But you see, in the second one, he was to submit 3 and this returns, the turnover. He submitted 3, but for different years. So on that count it goes. Out here, he's not required to submit any turnover. He submitted 2. So why can't the third one be exempt? Out here, there's no cheating. He submitted 2 instead of 3. When you're exempt from submitting all 3, he has submitted 2. You see, in the earlier one, he submitted 3, but they were wrong. Out here, he's exempt from submitting all the 3 years, but he submitted 2. So third one, so he's exempt.
is exempt. Otherwise, my lord, these are mandatory documents. If you go by
No,
our
mandatory document, even 3 is mandatory. When you come to 3, section 3, clause 3,
my lord,
come to clause 3. Clause 3, 49,
my lord.
page 49. It says here, following documentary proof is needed. Qualification, eligibility criteria of the bidder. Okay. So this is a mandatory condition, and 3E provides that it is mandatory. Because it only exempts
Yes,
MSCs.
3 exempt, my lord.
It exempts MSCs only. So that means those persons who are not MSCs have to submit. So in that case, if he has submitted 2, why should he not be exempt for the third one?
I'm getting with you, my lord. But my
Of course, he can
But
take advantage.
my lord will only record my submission that, my lord, he did not seek availing that exemption. He has, my lord, uploaded. He has submitted.
No,
two years document.
where does it say that when exemption is taken, he has to make a mention of it? Is there in a form,
He
tender form?
he need not submit, my lord.
No, he did not submit. So he submitted 2. What is wrong?
Submitted to my lord. It's like, my lord, he was not supposed to sit for the exam. He would have given a pass mark, but he sat for the exam and he paid.
No. He was supposed to sit for 3 papers. He sat for 2 papers only. Third paper, he's exempt.
I'm leaving it to them.
One exam, 3 papers required. He
I'm
submitted 2.
My lord, I am leaving it to Lord Speaker.
Of course, he can take advantage of that, maybe in a appeal, he saying that look out here, but we can differentiate. In one, he has to submit those 3 years, he submitted only for it. But then again,
He submitted for 2 years, my lord.
he submitted for 2 years.
2 years, meaning thereby, my lord, he did not have the third year. And my lord, he
How do you know do you have the third year? Do you have the third year? Yes. Where is it in your writ petition?
I've not submitted it because by mistake we have not done.
everything is mistake, my lord. My lord,
It happens, my lord.
my lord, tender is a very technical issue, my lord. Mistakes only, my lord. My lord knows, my lord. Let the tender goes, my lord. Every day, my lord is
Right.
taking up this matter, my lord. My lord,
That- I'll have to ask my client, my lord, at this moment, I think.
You submitted turnovers for which year?
2020, 22, 23, I did not. 2021 and 21.
So my lord, when is, these are before the authorities, my lord.
2022, 23,
22, 23, I'm not sure.
submitted for 2 years.
In
So-
their affidavit itself, they have stated.
So my lord cannot, my lord, they cannot accuse us with arbitrary. My lord, no. He submitted this before us and this was before us. So we have to give marks. He has set for an exam, then we have to give marks. We gave marks. This is like this.
Why did you submit?
He submitted. That is the problem, my lord. And at par we have
So far as the other respondents are concerned, my lord, they have also submitted,
submitted
but
and
not in terms of the tender closing.
my lord,
Other document,
let,
that's the thing.
No, with regard to 13H.
13 HCS,
Who?
manipulated document, I can show. now.
That they will have to decide
Ah.
whether it's manipulated or not.
So wait, my lord, Lordship will just examine one. It will be clear. On the face of it, I can show. Lordship will just give me an opportunity, 2 minutes.
I do not know whether we should go into that. We cannot do the
Lordship may not
tender
go into
evaluation.
that, may not, but just give me an opportunity. to
Show
show.
me.
verified, my lord. We verified, my lord. Each and every, my lord, that is why,
We are not a credit authority on that.
my lord, that is why
Lordship may not take into consideration.
marks
but
and marks
give me
for us,
an
my lord, to
opportunity
verify the
to-
document.
Yes,
No. This is again problem is. But tell me one thing. If a person has to submit his turnover for 3 years and he's exempt from submitting the turnover, he submits only 2 years. How does it matter?
No, man. He doesn't submit. If he has to claim exemption, he has to claim exemption in the very first instance. Not, my lord,
where, my lord?
he will submit for 2 years and then when he fails, then he will
Under
come.
which clause?
My lord, he should not have submitted 2 years. He never.
No. Where does it say that? Where does it say that? Let us see 13, 3.
Page 49 of NPSO.
They are exempted from prior turnover and experience.
Yes.
They are exempted.
Exempted.
Huh.
But my lord, he has to claim that, my lord. He should not have submitted.
As long as he shows that he is a small enterprise, that's enough. What do you mean he should claim? Does he have to write an affidavit?
No, my lord.
I am now invoking clause 3E of the
No,
tender notice.
no, my
How do you want? How will he claim?
My lord,
Is there a
should not have
form?
He should not have submitted this document. Once he submits, my
In
lord,
3,
then my lord, we will verify, my lord.
3E itself indicates the bidders need to submit up to date copy of so and so issued by the Ministry of. This is how we claim it.
So he submitted for 2 years. He did not submit for 1 year. How does it matter? It's not a question of submitting the wrong year.
My lord, once he submits, my lord, then my lord, he claims to have document. We will verify.
Both the problem is none of you all are helping me with any judgments or citations or something.
On this
And
particular.
now, once I pass the judgments, then of course, when you go in appeal, you will bring out all the citations. You all should have done the
Tried my best, my lord. I've searched for 20
prior.
years, my lord.
Anyway, this judgment is
I've searched for 20 years,
very
but no
difficult.
judgment, my lord, could be.
I know, it's difficult. You see, there are two ways of looking at it, like I said. One is exemption given, not to submit document, you have submitted and giving wrong information which was not required. Not wrong, but information which was not required.
Not
The question is, when a person has been given an exemption and he has not availed of that exemption,
availed.
you have not availed, you have submitted the document, but
How to,
now whether those documents are to be ignored,
how to
that's
avail,
the thing.
My lord, I'm just putting it in a very plain.
How
way,
to
my
be
lord.
ignored?
how to avail the exemption is given in clause P itself. by submitting the Udayam certificate. Once I
Mr. Counselor, please understand. Look, there's no, there's three says what? Three says that you did not submit documents. You do not need to show your experience and turnover experience. If you can show that, if you can show your within number. Now, you have shown your within number, at the same time you have submitted document, which was not required to be submitted. Now, is it your case that the documents which was not required to be submitted uh, because of the exemption clause, the submission of the same
could not affect my
is one, and that it should be overlooked, even if it's not in terms of the tender note.
should be overlooked. That's my submission because it's an exemption granted, my lord.
Okay, I've heard.
My lord, is it
Next,
my lord?
next,
Uh,
the last
my lord,
one,
in-
but I'm going to take some time.
20.
Huh?
Yeah, 20 and
In this case, my lord, all the documents were in order. They
Then
say
let me see the page clause. The disqualification, which page? 67. C, not in terms of C.
they say the certificate which are submitted is not the one that was required to be submitted to the authority. It's something else. My lord, I don't understand how it's different. Otherwise,
C is exemption clause.
exemption clause that Udayam certificate, which I am required to submit, I have submitted, but they say it's not in terms of clause 3. So how that is, otherwise I have submitted all the.
my lord, they are wicked. Let him finish.
No, we're eagerly waiting for your response.
My lord, now I will read this 3E. He is
Correct.
But I'm not aware of this case, so I'll not make a submission, my lord. Let him clarify. Maybe I have submitted wrong.
I do not know even. There are so we're waiting.
Yes, my lord, 3E, my lord, I'm reading, my lord. My lord, first part I am skipping, my lord, that is, I'm not into it. The bidder needs to submit the up-to-date copy of the certificate of registration of micro and small enterprise to them registration certificate issued by the Ministry of Micro, Small and Medium Enterprise MSME,
Correct.
Government of India. Moreover, the bidders must be genuine manufacturer of handloom. My lord, this is very important.
Correct.
Moreover, the bidders must be genuine manufacturer of handloom and that clearly mentions in the Udayam registration certificate. In case of MSME, payment of EMD and FSR exempted, my lord. So basically, my lord, that part, manufacturer of
It must be mentioned in the certificate that he is a manufacturer of handloom. So it's not mentioned, is it?
my lord, this is the document. My lord, we have downloaded. It's written there. Manufacturer of other machinery of textile apparel and leather product, etc.
Okay.
So, my lord,
So he's a manufacturer of machinery.
and my lord,
And leather
apparel,
product.
clothes and those things, my lord.
Okay.
He is not. So this is what, my lord. These two, my lord, as if like I am a my lord.
No, I understand. No need of your examples. Examples, so that's my job.
I'm not speaking.
I am submitting this document, my lord. I'm just put a flag into it, my lord.
It's not in your affidavit.
It's in my petition also.
It is affidavit. Page 60? Page 60. Is it?
Yes.
Given the
Okay.
It should be, my lord, waiting room. Those things should be the room for these, now for room. So, my lord, that is a different registration, my lord. Again, if you go by other people have, there, my lord, it is that code is 28261, manufacturing of machinery and preparation of textile fiber, spinning machines for preparing textile yarn. Those, my lord, in that head, my lord, it has to be done. I will just like.
it is my I will not dispute that. But just one submission on this, my lord. I have filed an additional affidavit, my lord. Reply starts from page 179.
Page 179.
For this case, my lord, based on the same certificate, my lord, the same authorities
Page 179. No, where is 179? I don't have.
in Bunty's case, my lord.
Bunty's case. Okay, yes.
Affidavit in reply filed by me.
Affidavit in reply.
Filed by me. To the affidavit in opposition filed with the respondent number 3.
Yes.
My lord, based on this same
Which page? Which page?
page
In a page?
199 onwards, my lord.
199.
These are work orders, my lord, based on the same certificate, the same department, the handloom and textile authorities, they have issued work orders to. Just for my satisfaction. Lordship may consider-
Unfortunately, the clause C provides otherwise. And unless you challenge clause C,
for my satisfaction, I am facing them.
okay, that you have been asked to supply
For
loom
the same department,
for
based
supply,
on, based on this
page 199, no?
one,
Page
199
199.
onwards, my lord. 199 onwards up to
You have been asked to supply
looms,
looms and accessories. So looms and accessories means what?
handlooms, my- based on the same certificate.
My lord, earlier tender, we did not have this clause, my lord. We
Correct.
have inserted. this
So
clause.
he was not,
It's a fresh.
okay.
So during that time, my lord, it was not.
Anyway, the clause is not under challenge. Clause 3 is not under challenge. Clause 3 clearly provides that the certificate should contain this.
Otherwise, my lord, all the documents are in order in Bunty's case. So in case that certificate is not in order, don't give me the exemption, other documents are there. That would be an alternative. Because all other documents are in.
All of it, but the basic, his very foundation fundamentally is wrong, my lord. He is, my lord, a person who is registered for making apparel, clothes and all. Here,
That is not in dispute that all other documents have been submitted.
my lord, here
That's the
we
alternative.
need a person, my lord, who should be registered to making, my lord, loom.
It says that the bidder must be genuine manufacturer of handloom that's clearly mentioned in the certificate.
Certificate.
So in the certificate is not mentioned.
Then I'm not entitled to the exemption. Turnover.
No, no,
and
that is one thing.
Yes,
But this, you see, let us see the NIT.
it's not
Let's
the
start.
case that non-MSCs are not entitled to participate.
Let us see, let us
See.
see the NIT. Where does it start?
See, it
Page?
starts from page 34.
Who can participate? Let us. Notice so and so for empanelment of manufacturers / suppliers. For supply of handloom into the beneficiary.
Not restricted.
Yes. Yes,
Yes, my lord.
this e-tender notice
Yes, my lord.
is for empanelment of manufacturers and suppliers.
Yes, my lord.
It does not restrict itself to manufacturers. So even if he does not manufacture handloom, but only manufactures the equipment and the leather product, he comes under supplier.
But my lord, in three, we have categorically, my lord.
No, but CE
Yes, my lord.
would have to be, would only relate to manufacturers. The exemption given under 3E is only for manufacturers, not suppliers.
And who are having MSc registration. There may be persons who are not.
Correct.
MSc.
It's so in that case, he's got a case. He cannot be denied. So one to against you for sure. This one to in your favor. Two are in the middle. We have to decide.
Trouble is with the lordship.
Huh?
Now lordship, trouble is with your lordship.
Correct. Now it's my headache.
But in Daivaki's case also, my submission would be, my lord, once it is exempted, my lord, because the documents are.
Yes, anything?
My lord. My lord, he is the supplier, man.
Correct.
Then he has to, my lord, upload a dealership authorization certificate from the manufacturer.
Mr. Counsel, that was not the reason you are disqualified.
My lord, he was,
That was not the reason you are disqualified. Please look at your document.
yes, my lord.
Can you, now, have you taken that ground in your affidavit? Have you taken that ground anywhere, which you are just submitting today? Can you make submission beyond your pleading?
My lord, I am on my lord, 3E, my lord.
Yes, even I am on 3E.
3E,
3E is for what? Is only for manufacturers.
Three-
3E is not for suppliers. Let us be very clear.
my lord.
3E is only for manufacturers.
Now, my lord will come to page 9 of the writ petition.
Page 9.
Page 9, the very first paragraph. My lord.
Yes.
How he introduces himself to the writ petition. My lord.
Yes.
The writ petition, that the petition number 1 is a proprietorship firm engaged in business of manufacturing, handloom, and accessories. He doesn't say, my lord, I'm a supplier. He said, I am a,
Anyway, it doesn't say he's a supplier, but his supply order shows that he supplies handloom.
my lord. He
It is
says
not-
that- He says that he has claimed to be a manufacturer.
Okay, so what? But then his manufacturer also includes supplier.
My lord, no, supplier, my lord, means he has to avail it from manufacturer. And meaning thereby, my lord, once he has to avail from
No, we cannot go into such technicality.
my lord,
I understand. No, we
he
cannot
has to
go.
have a dealership certificate.
No, you see, the thing is this, he is a manufacturer. Only problem is this, his certificate does not show that he's a manufacturer. That's all.
My lord, he is a manufacturer of different good. He apparel, my lord, not of loom. My lord, he doesn't,
Then how do you,
My lord,
how do you take care of page 199? Page 199, how do you take care of 199?
my lord.
What
My
does it
lord-
say? What does it say? Look, you're holding him to his
No,
to
no,
his averment. Now
Right.
now he's going to hold you to your supply order. Please come to 199. What have you said? This is to certify that the following, what does it
Supply.
say? Supply.
exactly, my lord. That was, my lord, during, that was for supplier,
Enough,
not for manufacturer.
enough, Mr. Counsel, no point. We are wasting our
There
time.
is computed, my
We are wasting our time. I know I'm going to pass the order now. I cannot put everything in CV. Right, last one. Heard Mr. B. Sharma, learned counsel for the petitioner. Also heard Mr. Ardhar,
Aye.
learned counsel for the respondents number 1 to 3. Mr. D.K. Nath, learned counsel appears for the private respondent. Okay. Mr. Ardhar, the learned counsel for the state respondents number 1 to 3. Submit that the petitioner, you have submitted all your documents. Yeah.
It's not repeated.
Okay. Submits that though the petitioner had submitted all his documents in terms of the NIT, comma, the petitioner was to submit. The petitioner was not a genuine manufacturer of handloom, comma, as the same was not mentioned in the Udyam registration certificate in terms of clause 3 bracket E of the NIT. he submits that a perusal of the Udyam registration certificate number Udyam AS 23 40255 shows that the petitioner is a manufacturer of what? Manufacturer of machinery and equipment for textile, apparel, and leather production. Correct?
Yes, sir.
Leather production. While clause 3 of the NIT requires the bidder to be a genuine manufacturer of handloom. He submits that there is nothing to show in the petitioner's Udyam registration certificate that the petitioner is a manufacturer of handloom. As such, the petitioner's bid was disqualified as his Udyam registration certificate was not in terms of clause 3 of the NIT. Next para. Clause 3E of the NIT states as follows. Page 48. Okay. This para. A reading of clause 3 of the NIT clearly shows that micro and small enterprises, bracket MSE, MSE, bracket, are exempted from submitting documents relating to prior turnover and experience in all public procurement, subject to meeting quality and technical specifications. So further, the bidders who are MSC need to submit up-to-date copies of the certificate of registration, that is Udyam registration certificate, issued by the Ministry of Micro, Small and Medium Enterprises, bracket MSME, Government of India. The bidders should also be genuine manufacturers of handloom, which are clearly mentioned in the Udyam registration certificate. Next slide. Clause 3 only relates to manufacturers, while the NIT in question, dated 11/1/2024, is for empanelment of manufacturers slash suppliers for supply of handloom and handloom accessories. The NIT does not bar suppliers from submitting their bid in respect of the NIT. annexure R/C wholly. Collectively, collectively. Of the affidavit in reply dated 20/09/2024, submitted by the petitioners, show that supply orders have been issued. No, shows that the petitioners, shows that the petitioner, MS Bunty Handloom Product from Nalbari, Assam, has been empaneled as a supplier for supply of looms and accessories, handlooms and accessories in the block level clusters being implemented in the state of Assam, Meghalaya and Arunachal Pradesh under the National Handloom, what is this, NHDP? National Handloom Development Program. Huh? Development Program. Development Program. Next up. Though the, no, the writ petition, the writ petitioner in para 1 of the writ petition have stated that the petitioner number 1 is a proprietary firm engaged in the business of manufacturing handloom and handloom accessory. And is a registered and is also registered as a MSC under the Ministry of Micro, Small and Medium Enterprise. From Government of India. The petitioner has also made averments that he has been supplying handloom and its accessories. The fact that the petitioner is empaneled as a supplier of handloom and its accessories in terms of annexure R/C wholly in the affidavit in reply dated 29/2024, not being controverted by the respondent, the same would have to be considered to be an admitted fact in terms of the judgment of the Supreme Court in the case of Nasim Banu versus President. Next part. Though the petitioners with their registration certificate may not have specific, the very fact that the fact that the petitioner is considered to be a supplier by the state respondent, shows that the petitioner's bid cannot be disqualified only because the idiom registration certificate does not specifically mention that the petitioner is a manufacturer of handloom manufacturer. In that way of the matter, this court is of the view that the disqualification of the petitioner's bid, technical bid or what? Technical bid, on the ground that the same is not in consonance with, the same is not in terms with, what is the word? Not in terms with clause CE of the NIT is found to be arbitrary. That the disqualification of the petitioner's uh, technical bit in terms of in terms of the meeting minutes of the technical evaluation committee of the e-tender notice dated 11/1/2024 held on 22/2/2024, insofar as it relates to the petitioner and insofar as it relates to the disqualification of the petitioner's technical bit is hereby set aside. The respondents are accordingly directed to
Next level, man. Now presented to the
consider the case of the petitioner, consider the financial bid of the petition.
whether
The petition is accordingly allowed. So, yeah, now give me the item, that one, with the one we're going to dismiss. That item.
Sonic,
Item two. We'll finish, otherwise it'll take, all this will take too much time.
yes, lot of things then my lord.
Too confusing for. You different.
On the last petition, my lord has already dictated this that one.
I've dictated most of it. No, not everything. I did not get your argument. What was it? Item one was? Okay,
step towards done.
just right. The petitioner's counsel submit. So you did not submit your income tax return
For 1
for one, and that was required under 13A.
13 but according to me, my lord, the tender issuing authority has understood the IPR also to be a turnover door.
No.
My submission, my lord, it is very distinct in the process. It is his submission, let me take my submission, that is what I'm trying to interest on your lordship, that in terms of clause 3B, the IPR is also a turnover door. If your whole lordship holds assets, that I'm in underwater.
According to you, ITR is a turnover document. No, but that is not their case. Their case is that you have not complied with 13H, not with
No, no.
3B. They're not on 3B.
It is 13H.
Correct. So their case is that you have not complied with 13H. That's what it is written.
The IPR has not been submitted for 2021. That is the case.
Correct. So 13H, not 3B.
My case is that I'm not required to submit exempted. So if I'm exempted, it doesn't matter.
Okay. You're right.
If I'm accepted, doesn't matter whether I have submitted or. That. The turnover document comes out from clause 3. Because tender issuing authority has understood in that.
Okay, right.
That's my submission.
So you say that ITR is a turnover document and accordingly comes under 3B, and because of 3E you are exempt.
And they have incorporated this document only to cross check the entries in the certificate. Balance. turnover certificate, balance sheet. Because the balance sheet may lie, but the IPA document being a statutory document cannot lie. So to cross verify only they have incorporated this IPA document. So it's a turnover document in terms of clause B, and the tender issuing authority has understood it in that. That's my support.
My lord, he was disqualified on 13H.
Correct, correct. No. You have to understand one thing.
Yes.
He says that the 13H document comes under 3B. That is his case. So since 3B is exempt under 3E, so 13H is not required. That is it. You're right. The petitioner's counsel submit that the petitioner had submitted the income tax return for the year 2020-21 and 2021-22. He did not submit the income tax returns for the year 2022-2023. As the income tax return is a part of the average annual turnover document, which also include audited certified balance sheet and and certificate from a registered chartered accountant / statutory auditor indicating the annual financial turnover during the last 3 years in terms of clause 13(1) of the NIT.
13H.
13(1) also. 13(1) is also annual turnover according to you. That's what you said. It is not.
I think
His case is 13I, not 13(1). 13I also comes under.
no.
Huh?
13
What?
13 is both are turnover document. He takes it 13H, 13I.
No, that's the same document. He says they are all part of the annual turnover document. Annual turnover document, according to him, is in 3 parts. One is 13I, one is 13H, and one is under 3B, the turnover document. You are like confusing me. Where am I?
That's for the
No. I was saying a lighter weight. Huh? Huh? Just where am I? I got lost. Which page is that? I see. The registered chartered accountant, statutory auditor, indicating annual financial turnover. Nah? During the last 3 years, along with the average annual financial turnover required under clause 3P of the NIP, comma. The submission of the non-submission of the income tax returns for the year 2023, 2022-2023 in terms of clause bracket, was not required, was not required in view of clause bracket E exempting the submission of documents required under clause 3B. Then that you make it in para 5A. And the stick. Stick A, huh? Yeah. Mr. Ardhar, Learned Council submits, Learned Council for the State Respondent submits the clause, submits that the submits that clause 13(8) does not come within the ambit of clause 3B. He further submits that the petitioner had submitted the income tax return only for the years 2021, 2020-21 and 2021-22. So income tax return had to be submitted also for 2022-23. He submits that as the no, that's all. That's- So you have submitted all the documents, correct? Correct, correct. The issue to be decided is whether the documents required under clause 13(8) would come within the ambit of the documents required under clause 3B of the NI. And as such, whether clause 3E would allow for exemption, would allow the petitioner, would exempt the petitioner from submitting the ITR return for 3 years, as required under clause 13(8) of the NI. The further question is whether the word turnover includes the word ITR. Correct? Next, on considering the above, this court finds that that we'll put it that next paragraph. On on considering the issue raised, the issue to be decided, this court is of the view that the average annual financial turnover document would have to be considered to be different than an income tax return. And that the annual financial turnover and that clause 3B cannot include within its ambit clause 13(8) of the NI. though clause 13, though the income tax return can be supportive of the annual financial turnover comma, the annual financial turnover can never be said to be same as an income tax return. Full stop. So, then next. The above being said, comma, clause 13(8) not being, the above being said, comma, as income tax return cannot be said to be an annual financial turnover document. Comma, this court holds that the relaxation provided for MSCs under clause 13E, under clause 3 would not cover the documents required under clause, will not cover the income tax return required to be submitted by a bidder under clause 13. As the petitioner has submitted only the ITR for 2 years, which is not in consonance with which not in consonance with the requirement of filing the ITR for 3 years. Comma, this court does not find any infirmity with the decision of the correspondent authorities in disqualifying the petitioner technically. The writ petition is accordingly dismissed. So that part. 3 and 4 are reserved. Right now, 1-1.
Yes, I don't. Thank you. There are no judgments on this issue. Throughout the country, I've searched for all high courts. This issue, on this issue, there are no judgments. What constitutes the turnover?
I will make some corrections here and there. I've got to add a few things also here and there. I've got to differentiate between ITR and turnover and all a little bit. I will do that. So it will not come out so fast. Okay. It will come out maybe in another 4-5 days. It will take some time.
Two particular judgments are disposed of on today's date.
Yes, yes, today.
The other two are.
Other two are not, but the ones that are disposed of today, that also will take some time. Because I've got to make some corrections here, add some more things. I'm doing it because otherwise it becomes a burden. Damocles start hanging over your head. No?
Much obliged.
You put this also. No?
Here, my lord. Claim of outstanding dues from the states for Assam from the society, my lord.
Yes, who is it? Yes, what to do?
After your lordship does direct, my clerk went to the section law and it found that no such certificate has been filed by the clerk. It was given to the clerk for filing and it was not forwarded. No such record is there. But the copy has already been furnished to the other side. They have filed their reply. So what I am proposing, Lord, let me have a copy of the application. I have also asked for the copy that is with the officer. Thereafter, let me.
You see, the problem is in this writ petition is there, affidavit in reply is there. That affidavit in opposition is not here. So what has happened? They gave it to you. You filed your reply, but they did not file it here in the registry.
That is,
No, is it going to be filed?
Doctor, I am requesting for a copy from the that copy I will find it.
Correct, Mr. P. Nair, learned counsel for the
Huh?
AIDS Control Society. Submits that. On verification, he has found that the clerk had not filed the affidavit in opposition. Though a copy of the same had been provided to the petition. The petitioner shall give a copy of the affidavit in opposition to. You let him take photocopy. And he shall submit a copy of the affidavit in opposition to Mr. P9, who shall take steps for filing the same within 1 week. Within a week. So Mr. P9 shall also obtain instructions with regard to whether, with regard to why the amount claimed, that is 7,64,676 have not been paid to the petitioner. This is the matter after a week. 21st. 21st. This is the matter 21st. Yes.
We will be filing an exhibit in reply for
You want to file affidavit in reply?
therefore, time for getting
Affidavit in reply to what?
to the additional affidavit filed by the
Additional affidavit filed by whom?
filed by the respondent of the
Two.
2, 3, and 5.
Okay, right. Mr.
Sumanta Taluka.
Suman?
Sumanta Taluka.
Sumanta Santo. Appeal for the petitioner. Mr.
And Kalita.
N. Kalita appeal for
Industries and
Industries and Commerce Department. Well, Mr. N. Islam appeal for? That's point number 4. Are you filing anything? When? Okay. Mr. Pelto, sponsor for the petitioner. He's granted how much time?
10 days.
10 days time to file affidavit in reply to the additional affidavit filed by the respondent number 2, 3, and 5. This is the matter after 10 days.
What of it?
Who is for the respondent number 8? Oh, you have that. Yes, what is to be done here?
The matter pertains to my land was acquired. I have been paid the compensation in respect of the land, but in respect of the structures, my allegation is that the compensation was paid to the respondent number 8. And respondent number 8 has received the same. Now, suddenly out of nowhere, the government departments have came to my land with a view to demolish the structure. So that's why I approached this on court, because I'm entitled that my structures over my land has to be assessed, an estimate valuation has to be given, then only they can demolish.
Correct.
So that is the matter before the Honorable Court. And to that extent, we
Yes,
approached
the
the
order passed.
yes, on the very motion day.
So why was the money given to the respondent number 8?
Maybe the respondent number 8 might have claimed it to be his land, because the number is same. It's a park, my lord. It's a park.
It's a part.
It's a park. It's a common path used by both the petitioner and the respondent number 8.
Then if it's a common path, then how can it be yours?
My lord, as per the MOU, means there was a sale date in respect of which.
But when the document, is there any document
Yes,
of yours covering that portion of land?
Yes. There is a,
And according to in your document that portion of land is yours.
my lord, he agrees. He also filed a partition case, wherein he says, I own this portion of land. And in fact,
You are not related.
no. It means I purchased the land from the respondent number 8.
Or you purchase the land.
Land from respondent number 8.
Okay.
So my lord,
So these are disputed questions of fact. How
No,
can we decide?
even the report is there.
Should I go and measure the land or something?
No,
Who is going to do it?
my lord, the simple question is that I was given the compensation in respect of the land.
But you said he has been given part of it or something.
The land, it's a path. If your lordship just.
No, if the money was given to you,
Yes,
then you said that some portion of it was given to him. Nothing was given to
my
him.
lord, it's a path.
Huh?
Virat was given.
What is Zirat?
The structure, the boundary walls, the compensation for the boundary walls, the damage to the road, the security rooms, that was received by him. And since this is a path, your lordship, my only submission is that, like, left side boundary wall belongs to him, right side boundary wall belongs to me.
Is that a fact?
Dedicate 50% belongs to you, 50% path belongs. Okay, both of us, we have to cut the. It's just on board. According to that,
I'm not disputing. That is another matter which is subsidized. Who has constructed the bank? Now the question arises when the government pays me with regard to the compensation in respect of the land, your lordship. So government is sure that this is my land. That's why government paid me compensation. So over that part, your lordship, I am entitled to the structures company.
The structure, what is it? It's a house.
No, your lordship. The boundary walls are there, main gates are there, security rooms are there.
Security room? What is-
Security room. It's a path, your lordship. There is an SS to the backside line.
You have a security room.
Security room and the.
For what? What security room? What is it?
Your lordship, the entry port.
No, there are guards inside. What are
Guard,
the
guard. Security guard.
security guards?
Security guard. And in fact, your lordship,
Yes, what is to be done? Are you filing affidavit or what? Can it be decided? There's nothing.
my
Are you
lord,
filing anything?
this part is given to me.
Please file some affidavit. Please file some affidavit so that we can take a decision. Tomorrow you will go and appeal and say that I was not given a chance to file any affidavit.
my lord, as per order dated 81/23,
Yeah.
there is an observation in the last paragraph. In view of the statement made in the representation of the petitioner dated section 6/5/2020, that compensation for loss incurred by the petitioner by demolition of permanent construction was allegedly unauthorizedly received by the respondent number 8. Court is inclined to provide that pendency of the writ petition shall not be a bar to the Deputy Commissioner Kamrup Amingan to disclose the petitioner the amount of compensation paid by the said authority in respect of permanent construction standing over the land of the petitioner. In that regard, there also a affidavit comes, your lord.
You see, this land of yours has been acquired under what act?
Under the Assam Land and Land Acquisition.
Is there some award made or what is it?
Yes, award was made. And I have received in respect of the
In
land.
the award, you're the owner of the land.
Yes.
Yes, are you filing any affidavit?
Oh my,
No.
we have received instruction that it is long back, my lord, January
So?
2023.
So how does so
My lord, it has directed the cycle officer to personal hearing both the parties. And it was going on. Now, I don't know the outcome.
So, your lordship, the case was this, annexure page 49. We filed an application.
why is this matter here? These are all facts.
Your
Factual
lordship,
issues.
that is why. Your lordship, this annexure 7, page 49, we submitted a representation before the Deputy Commissioner stating that in respect of Virat.
No, you please page 5 matter.
Yes, sir.
Yes, that's okay. Because these are disputed questions of fact
Right.
involved. And then not only that, when the compensation is involved, then you have got to show where is the award, all that. And you have got to you have got to make it clear as to who is to get what.
Hello?
Okay,
Regarding land.
Huh?
Regarding land, compensation was paid to him, and he is also co-partner for the road and other construction developed portion. His name appears, and he was given the here. Then he objected. If he asked the cycle officer to give a personal hearing both the parties, then it was going on.
is there I do not know what's the Assam Land Act, but as per the LA Act and the 2013 Act, there's a provision for reference. Here also there must be, so why should this matter be pending? Anyway, you go before the appropriate bench. This is bench 5. Right. Heard the counsel for the party as the matter pertains to bench 5, registry to verify and this the same before the appropriate bench.
The interim order may be gone.
Interim order to continue to the
Develop.
Councillor filed affidavit regarding default of the security amount. They are starting the default of the security amount.
Where?
They have
I do
filed
not
an
have.
affidavit, today morning. They've admitted that the 15 lakh some dispute regarding royalty, that will take. appropriate-
That you take appropriate.
You may file a
Last
writ petition or maybe a suit. Security deposit, they cannot deduct any, but they deduct. Paragraph 9 and 10.
So it will be minus all this. How much does it come to?
54,
Wait. One is, so 16.55 will have to be cut
from 5494 to 071.
from 54.94.07.
That is the security amount. Comes to 3907. This amount they should pay, my lord, at the 16. We'll take 15 steps, my lord. We'll have to file.
Comes to 38.39.071. Okay, right.
They should pay it immediately, but they are supposed to pay in the year 2017.
no,
They are supposed to pay in the year 2017.
Yes, my lord.
And when did you come to this court?
No, because. they
When
have
did you
paid-
come to this court?
They have paid the 20, because of COVID and all, my lord, they have admitted. But the 25 lakhs they have paid only in the year, out of.
Yeah, the torch light is lacking. Your battery will go.
demand has been
Right.
submitted.
Huh?
Demand has been submitted.
But you've got to pay, madam. He's done his work. Here, it is money.
Yes. Yes.
You have eaten the, you have eaten the interest. Right.
They have paid for.
No interest. Sorry. You can go to the appropriate authority.
If they fail to pay within the time stipulated by.
You go to the appropriate authority.
Already agreed to pay.
Oh, read court. No. Otherwise, we'll be flooded with this everything. Right. Heard Mr. B.D. Das, Senate Senior Counsel for the petitioner, assisted by Ms. Ardeka. Also heard Ms. J. Gogoi, Learned Counsel for the respondents number 4 and 6. The petitioner's case is that pursuant to a short notice inviting tender dated 6/5/2014 issued by the respondent number 2. The petitioner who had passed, the petitioner was selected as a successful tender pertaining to one of the project work, namely, inverted commas, the improvement of Lanka Garam Pani (LG) road portion from CH.0.00 m to CH.14,000 to 14,000.00 m close under RIDF dash Roman 19 of NABARD bearing package number DIMA dash HASO dash RIDF slash, no, dash Roman 19 slash B dash Roman 2 slash 12. The petitioner completed the project and after expiry of the defect liability period, the petitioner made a claim for release of the security deposit amount of rupees 79,99,111. The project was completed on 2/7/16. The petitioner received an amount of rupees 25,05,040 out of the total security deposit amount, leaving a balance of rupees 54,94,07. The petitioner's counsel submit as the said amount, the said balance of petitioner still. Ms. J. Gogoi, counsel for the response number 4 by relying upon the affidavit in opposition filed on behalf of the respondent number 4. Submits that the Accountant General bracket audit, SM, PA dash RIDF audit camp Haflon, white letter number POS, white letter dated 3/2018 has deducted rupees 16.55 lakh from the balance amount payable to the petitioner on account of forest royalty, value added tax and income tax on forest royalty. She submits that the petitioner would now be liable to receive rupees 38,39,07. Correct? I have heard the limit cost for the para 7, 8, and 9. No, para 8, 9 and 10 of the affidavit in opposition filed by the respondent number is reproduced herein below as follows. The government, the submissions made by the counsels for the parties and the government made in the affidavit filed by the respondent number 4 clearly show that the respondents have admitted to the fact that they are liable to pay to the petitioner security deposit amounting to rupees 38,39,07. In view of the above, the respondents are directed to pay the said admitted amount to the petitioner within a period of within a period of 2 months. 3 months. Okay, 3 months. It'll really come in. Within a period of 3 months from the date of receipt of a certified copy of the cost. No, no. And then the financial year is ending. They'll give it to you by that time. The with regard to the with liberty being given to the petitioner to approach appropriate forum for recovery of the other amount, if so, 16 point, if so advised, Yeah, 16 point, have no need. And therefore, respondent number 3, you are the main person, you've got to file a affidavit, It won't try to file that. I know, but they have laid the blame on the RCF. Mr. K. Gogoi, then counsel for the respondent number 6, prays for some time, obtain instruction and file affidavit. System. The affidavit of the respondents number 4 and 5, bracket CRPF, is to the effect that the vehicles were hired for the purpose of use of the CRPF and the hiring charges of the same was to be paid by the respondent number 3. System. Mr. K. Gogoi is accordingly granted 2 weeks time to file affidavit. This is, yes. Mr. AK Data appears for point number 4. This is the matter after 6. Give it. Like. Same. Affidavit is there? Yes. Okay, right. In item 4, you write Mr. K. Gogoi appearing for respondent number 3. And Mr. AK Data appearing for respondent number 6. What about revenue? And Mr. J. Handy appearing for respondent number 6. What, PTC, are you there? Are you going to, huh? You've got nothing to do.
Deputy Commissioner.
You've got nothing to do.
Somebody could, they have taken that on higher.
Okay, right. Mr. K. Gogoi and Mr. AK Data. Mr. K. Gogoi for point number 3 and Mr. AK Data for point number 6 are given 3 weeks time to find affidavit. Mr. S. Bora appearing for the BTC and Mr. J. Hunting appearing for the Revenue Department submit that they do not have any comment to make in this. This is the matter on. Public.
Can it be 11? Can it be
Item 21. You want your name to be reflected? Huh? Is it required?
Right. Item 26 order.
Yeah, my committee has been prepared, my lord.
Huh?
The committee is not to hand over the.
Committee
hand over
for
the-
what?
Committee has been prepared, my lord. And thereafter, my lord, 2 sitting has taken place. And a final decision has not been taken, yet survey will be done as regard to supply of all the pins and all other materials, my lord. But if they are seeking for one month more time to get the on-field verification.
Last time your AG had said that it will be paid.
No, it will be that committee and everything has to be done within a month, my lord. But in the meantime, the Durga Puja holiday and the Diwali and that subsequently another 2-3-4 days that parent visits are there, my lord. So they cannot be completed. my lord. The committee has been prepared and the two sitting has already taken place. On-field verification is required, my lord. Then after everything will be.
Right, Mr. S. Bora and council. Also, whatever. As per last order, they will comply within 4 weeks. But they submit. So, and if I also appear before the committee law
Yeah,
on 19/9. That may be recorded.
and the signature is there, my lord. His signature is also there in the.
He appeared.
And also the meeting. He is also taken on board.
The first inter-committee petition appeared on 19. 1910 was. What is this adjourning committee, this, that, all the-
On-field verification with the supply. On-field verification that will be done by the committee.
It says for a submitted. Letter dated 11/11/2024 issued by the principal secretary of a BTC. Which is to the effect that 1 month time is required to complete the verification report. It is to be submitted before the inquiry committee, who is to take it on the aim of the petition. Accordingly, leave this matter on give a date. Okay.
Lordship may kindly get Lordship's order, my lord, dated 1/8/2024. No one is appearing in this case, my lord. This is a matter regarding, my lord, payment of the contractor's bill, my lord.
As per the office note, learned advocates entered appearance. This is on 8/11. By filing wakalatnama.
The names of the,
Huh? B. Gogoi. A. Chaliha. What is this? So we'll issue for available warrant of arrest against them if the councils are not appearing. What to do?
the earlier rules did not appear, of course, if they find Wakalatnama. Because as per your lordship's, my lord, direction, my lord, the learned government advocate, my lord, informed them, my lord, thereafter they appeared, my lord. Been, my lord, long, my lord,
Okay, right.
2022, my lord,
Mr.
and the.
M. Data. No one appears for the respondent number 4. Even though wakalatnama has been executed by the respondent number 4 in favor of Mr. B. Gogoi, Mr. A. Chaliha, and Mr. M. Buya. This matter pertains non-compliance with the order dated
1990,
It is that page
11.
19, order dated 19/9/22, passed in WPC 4700/20. Where the respondents were to consider the contractual dues of the petition for payment of the advertisement. As no one appears for the petition, as no one appears for the respondent, this court is of the view that available warrant of arrest should be issued to ensure the appearance of the respondent number 4.
All the respondents, respond 1 and 3, of course, is left. 1 and 2 are also not appearing. They have received notice, they're not appearing. They have not even engaged in a council. Because the last order, my lord, that order, my lord, lordship, my lord, had
Okay,
passed.
before that, don't say. Okay, that's it. No, 1 and 3 received by employees on their behalf. 2, so it's okay. 2 has been received by respondent.
Let 2 appear, man. He's also superintending engineer. Let him come. 3, of course, has left the office. 3, I'm not paying. 1, the chief engineer, and 2, my lord, himself has received it. Let 2 appear. 2 and 4 appear, man.
Right, it's correct, right? As per order dated 1/8/2020. Notice in respect of the respondents number 1 and 3 have been received by the respective employees on behalf of the respondent number 2 has however been duly served notice. in view of the above reason and as in view of the above reason, comma, the respondent number, this is for the view that available warrant of arrest to be issued against the respondent's number 2 and 4. Who will issue? The CJM. Accordingly, the registry directly take steps for issuance of available warrant of arrest against the respondents number 2 and 4 to be executed by the concerned chief judicial magistrate to be executed through the concerned police station through the CJM Kamrup. This is the matter on. Sometime in this is the matter on 9 December. 9th or before the.
That be some time because this,
9 December.
so then we will take steps on the respondent one.
So who is 2 and 4? Who is the
Two
superintendent?
superintending engineer and the
And 4 is the.
four Miller is the new executive engineer will join. Well, we'll take steps to respond once again, Miller, because the difficulty is Miller, they put their employee to receive the paper. They
Right.
don't receive it themselves.
The petitioner takes steps for service of notice upon the respondent number 1.
Right.
Take steps for service of notice upon the respondent number 1 by registered for city visit today.
The difficulty is that they will receive it from their employees. That's the problem.
You find lucky.
That's right. Then that's the
In addition to the above, the petitioner shall also serve notice upon the respondent number 1 to Dustin. Visit TV and file affidavit of service. Level. This is the matter. But why is it the councils are there, they're not coming? Now they will wake up.
Neither etiquette nor answer.
It's the fight. AD card return back for respondent number 6 signature or one Ganesh Kutia. Who is Ganesh Kutia? Huh? So what to do?
So suppose they verify the check consignment.
Huh?
Check consignment.
What?
Check consignment, मतलब I register for.
Neither AD card or transcript. Nothing received.
Check.
This Mr. K.R. Patel, that part for the petitioner, that effect as per service of notice upon the respondent within 3 days. Is the matter of the following. Okay.
Pretty Lordship, can make kindly give 10 days time because we could not find the records in the division one. So we are trying to find it out here in the division cover, that each RE section, the rural electrification section, because the work.
You were given one last chance. Failing which the concerned engineer may be asked to produce the report.
What's the instruction?
We'll call the engineer. Who is it? Let him come.
But if they do not possess the record.
They will find it.
Just
They are in the
10 days
office.
or 1 week time, okay, we are trying to find it out in the RE section.
Huh?
RE section, in the rural electrification section of our visiting board. So we do not find your lordship in for any order, just 7 days. Because the work orders are related to 1993.
Right. Mr.
R. Bora.
R. Bora, appearing for the APDK. Pays for 1 lakh chance to produce the report. Mr. T.R. Sharma appears for the petition. The matter pertains to non-payment of contractual dues of the petitioner's husband, who has since died. Next para. This court by order dated 22/10/2020 has allowed the counsel for the petitioner to produce the report as a last step. However, the counsel for the APDC produce the report as a last. However, the same has not been produced. In the event, according to last answer provided to the APDC to produce the report from a fading week, the concerned executive engineer shall produce the report personally. Or we should do the chief engineer is there, better. Or what, who is there? Failing with the deputy, failing with the deputy general manager, or what? Oh, failing with the assistant general manager, York Electrical Division, can produce the report. On, this is the matter of when. Okay.
Public.
Or matter to the customer for handling. Yes.
Transportation also was not representing.
What to do? If it was the writ petitioner case, there was a way we could handle it. But respondents, what to do? Ex parte,
Because my lord, this petition is against an award which was passed, it's not against the,
okay.
and my lord, when the learned labor court started to proceed expertise, there was not even any service report. And
Then why not order 9 rule 13?
my lord, we had filed an application for vacating the party order, but the labor court refused to vacate. So both the award and that order is under challenge. Basically, my lord, the record would reveal in the award if the lordship goes. The petitioner could not, the workman could not establish his case that he was engaged by us, that he was terminated or removed.
Where is your senior?
Yeah, this coming up with some new data.
Wait, sir.
Photo 6 that I sent, but before, the labor fight has been, I will put that. Maybe tomorrow or the day after tomorrow, I will come up with. Somehow with. If you don't open the door, day after tomorrow or 2 parts, whatever.
Let it go, at least they'll wake up.
But they said warrant part, otherwise, also will say, the for the person, if there's anything, because nothing comes up. There's many possibilities.
You're not bothered to come here.
So I will say.
Yeah, three councils, Mr. Council. D. Gogoi, A. Chalia, M. Bhuyan. All three of you were not arguing together.
Dalia has to leave for some person. The morning is difficult.
I thought good, let them come.
But they will come when it is required. That's why.
Well, you have to call the other council, call them. Because they call them. Item?
Case is fair, that will be good. That case, regard first.
Yes, but dues of the petitioner have been paid or not?
Paid.
Then
But already. Yeah, that is.
what is to be done now? Inspector,
Close every.
okay, right. Mr. S. Das, learned counsel for the petitioner. Submits that all the dues payable to the respondent number 2 has been paid. All the dues payable to the respondent number 2 has been.
No, number one.
Response, no. Where is Mr. S. S. Roy? Respondent number 1 is somebody else. Respondent number 1 is the state of Assam. Number 2 is the workman.
And number.
Okay, submits that all the dues payable to the respondent number 2 have been paid. And
Already attained.
Huh?
Yeah, already.
and that the respondent number 2 has attained
Yes.
the age of superannuation
February 2000.
in October 2023. Yes,
My lord, as per my instruction, my lord. He was retired on 30/11/2023, my lord.
okay.
During as per the June order is the date, my lord. 16/8/2006, from the date of the suspension till the impugn order dated. This is no payment. And after that, my lord,
Till the
this is no payment.
from the date of
Suspension to the date of impugn order. So days of dismissal from the impugn.
from the date of dismissal
Sir.
to the impugn order.
That's the labor code. As per impugn order, bidder, he is entitled for 50% yes, ma'am. That amount, the date of suspension, he got. No, ma'am. And after the order, he got last done wages more than.
Let us see the order.
That order is kept from.
They will-
20, my lord. Last 11%.
So petitioner is entitled for reinstatement with 50% back wages.
Yes, that amount did not pay to me.
So this 50% back wages from which period?
From the order of the dismissal. my lord.
When was that? Naturally,
Yes, ma'am. He has got more than as awarded by the 50% back. And he after suspension, he got 50% with it. And after the order of the labor code, he got as per the order of the Honorable High Court, last done with this after section 73, last done with this.
you see the problem is, he's saying he has not received, you are saying he has received. Now, what am I going to do? I'm going to believe you or him?
Yeah. If Lordship want to close this issue, and the petitioner paid, the direction will pass, they pass the speaking order within a time period, because that what amount we are entitled, what amount they have to pay. If we are not satisfied that speaking order, going to come again. That is your.
You don't have to come, you can, when the writ petition is being, when he says that it is infructuous. If it's not infructuous, then we'll have to go, you can file an execution case. If he can withdraw the appeal anytime, the writ petition anytime. It is his case.
Right.
If you find that you have not been paid, you can file an execution petition.
For section 17B, my, when a case is pending before the High Court, my lord, I have to pay the full salary.
When?
When after section 17B, my lord, when a requisition is pending before the Honorable Court, my lord.
You have to get the full salary, correct?
But even then, my lord, also, they started to, a order was passed on the dated of 16/11/2018. After that order, my lord.
Mr. Counsel, the problem is, you see, he's writ petition.
My, I,
The only thing is that you allow him quietly to withdraw Then you file an execution petition. Saying that this is. Otherwise, I want to decide the entire issue, the facts, the merits of the case. Okay. Now, whether you see, whether you have got it or not, whether this court will decide, this court is only going to decide the legality of the judgment passed by the tribunal. Correct?
Correct.
So, he doesn't want to make a challenge of it, saying that everything has been paid. So let him withdraw it. On the other hand, if you find that no, what is statement is wrong, then you file an execution petition. What are you doing? You are, why are you trying to argue the case here? I don't understand. Then it becomes, then the decision of the tribunal becomes final.
Fine.
You should know when to keep quiet and to, and you're not helping your client at all. Yes, so what to do? You have to withdraw on the ground that everything has been paid.
Everything has been paid.
Okay, Mr. S. Das, learned counsel for the petitioner submit that as the petitioner has, as the respondent number 2 has, before that you write, Mr. S. Das appears for the petitioner while Mr. K. M. Hassan appears for the respondent number 2. Mr. K. Gogoi appears for the respondent number 1. The petitioner's counsel submits that as the respondent number 2 has been paid all his entitlement in terms of the award dated 16/8/2016 passed by the Labour Court Guwahati in case number 4 of 2015. The present writ petition has become infructuous. What? No. He wants to withdraw the writ petition. But
In fact,
he says that. He says it is not.
that is my problem will be another problem. Then I have to argue this case.
That's what.
Then
That's
I
what.
have to argue this. Then
Correct. Then we argue.
let them argue. But we already attend the retirement date.
What he wants basically, that's point number 2, what does point number 2 want? Is that all the payments should be made. That's all.
Yes.
Now the question is, he has attained, now he has retired. Now whether all his payments have been made or not.
Only payment.
Okay. So we will close this petition on the ground that all his payments have been made as submitted by you.
Yes.
However, if it is found that all payments are not made, then you should make the valid payment. Correct?
My second also will be there.
I do not know this. You are spoiling your client's
My
case.
lordship, lord.
Yeah. You are totally spoiling your
My
client's
lord,
case.
okay, go forward. Up to.
He's very too smart.
Lord, happening.
But
Lordship,
please take a seat. You don't know. It's like you are being given your khana in bed. And you are saying, no, give me when I go to the latrine, give me that time.
no, I apologize.
Who will have khana in the latrine?
I apologize.
You're not understanding the issue at all. We have pity for the workman. They are saying his only case is that everything has been paid. Now, so there's nothing else to agitate. So you should say, I'm okay with his submission, except that they should make an undertaking or submit a document saying that everything should be paid. That's all. And then if it's not paid, then you agitate. Correct. Mr. S. So Mr. S. Das, Mr. S. Das, Senate counsel for the petitioner submit that the petitioner has paid all his entitlement in terms of the award dated 16/8/2016 passed by the Learned Labour Court Body in case number 4 of 2015. Accordingly submit that the writ petition has become infirm. Mr. K.M. Hassan, Learned Counsel for the respondent number 2, on the other hand, submit that he does not have any instruction as to whether the respondent number 2, Dr. Workman, has received all his entitlements. He submits that the writ petition can be closed as instructed on the condition that the writ petitioner submits a document. No, issues a letter to the respondent number 2 stating the payments made to the respondent number 2 in terms of the award dated 16/8/2015 passed by the Learned Labour. Okay. Mr. S. Das, the counsel for the petitioner, submits that the writ petitioner will issue a will communicate the will issue a letter to the respondent number 2 or his counsel informing, stating the payments made to the respondent number 2 in terms of the award dated 16/8/2015 passed in case number 4 of 2015. Within 1 month from the date of closure of this case, in view of the submissions made by the counsel for the party, the present writ petition stands closed. With the direction being given to the respondent writ petitioner to submit a letter to the respondent number 2 or his counsel. The payments made to the respondent number 2 in terms of the award dated to past instance within a month from the receipt of a copy of this one.
What Monday were the- what are the-
But 2 let it remain, my lord. He has not bothered to appear. That 4 will not be called. Because 2 has not bothered to appear. He has not filed for number 1. 2 is a superintending Indian. That he has not responded.
I can, my lord, estimate. Otherwise, my lord, it will be the chief engineer will have to send it to the government for approval.
Okay, what have I said in the last?
On Monday, my lord, I will come up with one. Including intimating the person.
No, stop, next stop. Cut that. Mr. P. Gogoi appears for the respondent number 4 and submits that he will obtain instructions by 18. Accordingly, leave this matter on it.
I'm like a order passed by the total part affiliate authority, my lord. By which the going beyond his power, my lord, has reduced the penalty imposed by the EPF authority. Lord, the power to reduce or the damages or penalty is
vested on the central board of directors, not with the affiliate of they are under a statute. So this is number one. Another aspect is that the affiliate authority has followed by Herbert's finding, if we finding that we have reduced the, we have imposed the penalty, not on the rate fixed, but the different rate. That are two findings. So when we examine this, fact.
For study my tenure of the bank, so informed of the bank is currently stop the functioning. So 200 crore, more than 200 crore liabilities here from 1996. Due to the financial condition, the bank is completely non-functioning. Now government taking some matter, numbers of litigation pending and hearing is going on. The Advocate General also appearing in those matters. The matter is 690. There two decisions will come, either bank will liquidate or it will be continued.
Or it will?
It will functioning will start by the government. But only government can start the function. Because now the bank is stopped functioning completely. And
So then
only
they will liquidate.
considering the bank condition, this waiving of the interest
This cannot.
and the
what-
employee
what-
provident fund.
The
at least
financial
seven
condition
also
of the establishment is not related to the, payment of wages, because the payment of the
bank-
this is what the Supreme Court has held. Therefore, there's no relationship.
Yes.
Even if it is liquidated or whatever,
Then they will take from there only.
there,
The
but
liquidated amount.
but this lesser amount will be paid, that the employees will be,
My only
will not
submission,
get.
uh,
So this has to be adjudicated.
even though the consider the tribunal consider the condition of the bankruptcy, because the real amount also unable to pay by the bank. The penalty is to.
Well, you see, whether they can pay or not, that is not our
Yes, yes.
fault.
But otherwise, Lordship, if the tribunal order, legality and validity of the tribunal order, if Lordship will hear, then I have no. My senior.
That is what I'm going to hear.
Yes,
What
and
else?
I just inform the condition of the bank. Because bank has no.
So what to do? What to do? Assam State, Assam
my
State
fear is,
Transport Corporation cannot pay the retirement dues of its employees. That does not
We have,
mean
no
that we
objection
cannot
on
take,
the
we
dues.
should not take up cases against
Yes,
them.
sir. We have no objection on dues of the Lordship. Every employee is equally treated by the bank, Lordship. But after considering the bank condition, Lordship, the government will take it. Either it will start functioning or it will liquidate. If that difficult
That
will
is a
come,
different issue. That is
after
got nothing to
19,
do.
the hearing, otherwise my senior.
Huh?
After 19 case, all the cases are 69. It's 19 of it.
Nothing will happen on that.
Then look, that part I have no objection, only that part. If it wrongly, the appellate tribunal passed the order wrongly or rightly.
So do you agree with
I
this
can
submission?
only, I can argue, I can point out only the bank condition. Then maybe part Lordship will,
Surely, that's what I'm
Yes.
doing.
yes, yes.
So his case is that the tribunal could not have
Reduce the penalty.
reduced the penal damages.
Lot.
Tribunal also observe the condition of the bank. We presently, the real amount are able to pay. So the penalty question is done.
That is a different issue, Mr. Counsel. That is not an issue here.
Yes, sir.
What is the issue here? What is the issue in this case?
The legality and validity of the law.
Which order?
The order passed by the appellate tribunal.
So what is the
That
appellate
appeal
tribunal?
was prepared by bank law.
Yes, so what is the appellate tribunal do?
Appellate tribunal waive the penalty.
Penalty.
Yes, 6%.
So is that correct?
That
Good.
part,
No, I'm asking you.
as per
Forget
my opinion, that's correct, because Lordship, the condition of the bank is non-functioning bank. Even though if the allow all the amount, bank is unable to pay.
So it's correct. Yeah, it depends
It has
due to
considering
the
the bank.
condition of the bank.
Yes,
So how, prior to the appeal, who filed the case? Who filed the complaint?
I think program plan of it. Hello, the power to reduce.
Just a minute. Yes. Yes. Where? You can start.
Possible, the employees holding fund and miscellaneous provision.
How long will you take?
If you take for this,
10 minutes.
10-15 minutes, it won't take much time. Employees holding fund and cover no cover.
No, we don't have. You should have given, information with regard to this act earlier. So that we could have been prepared.
I find it readily available each time I remember, that's why I thought, right. Yeah,
No, no, you did.
okay, lawsuit says 14B proviso. Proviso, 14B proviso. Provided that the central board of lawsuit fine. This is statutory. Here, it's here. Second proviso, my lord. And upon satisfaction that they, it's a secret stuff. There have to be findings. They are subject to the secret stuff, and then only the central board can, not the appellate tribunal. Appellate tribunal power is provided in the section 7I.
7I.
Yes. It's like adjudication under section 7A, 7I.
So where is your order?
The 14B order, my lord.
Yes.
The main order which is put to challenge before the tribunal. That my lord will find. Page 34.
34.
Lord. After considering every aspect of the matter, the authority has passed the order.
Under 14B.
This, yeah, 1450. My lord, I take your lord to the page 35 or page 34 last paragraph of it, page 34 last paragraph, and whereas I checked the office report, page 34 last paragraph.
Yes.
And found that the interest payment of 59,30,550 is for the period from 4/2003 to 12/2009 has already been deposited. As such, I am charging the interest of 12 and 2009. It is also seen that huge damage in 2009 is due from 1,459 lakh. So deposit interest. Color number is also found that the statement of 2009 rupees 12 tax period. And whereas 32B employee social fund we provide 32B terms and conditions for reduction of waiver damages, central board may reduce the waiver damages levied under section 40 of the Act with basis to establish in case the change of financial in case where the board industry financial is reconstruction for reasons recorded in its scheme on this recommends waiver of damages up to 100% may be allowed. In other cases, depending on the merit, reduction of damages up to 50. And where the second provision portion B, the act that
See, for you, you might have read it 1,000 times. For us, it's our first time. So, most likely, you cannot jump word.
Lordship will, the relevant parts may not is Lordship page 35 last paragraph. Page 36 last paragraph. Last. Page
Yeah.
30. And whereas the period for which damages is to be levied pertains to the period preceding notification date itself, which amended the rates of damages, takes the rates laid down under the amended provision 32A.
This also not complete. Page 36.
36, and next page is page 30.
No, it starts, it ends with I. I take the rates laid down under. Cannot be.
Amended. Rate of damages. Take the rate under the pre-amended. The appellate tribunal has committed a mistake. We have the charge as per the amended provision.
I have to see how.
That is,
Jump
my lord, that is under your lord will the basically, my lord, the power to reduce the penalty is vested of the central board of central board. Second provision. And the tribunal, what tribunal did, my lord, the tribunal reduced.
Where is the power of the tribunal? Let us see the power of the tribunal. Where does it say that it cannot be?
Tribunal's power, my lord, is 7I, J is the procedure, 7I, 7L.
It can confirm, modify an order.
Modify an order.
Modify means what? Modify means
Modify an order.
modify means what?
Modify an order, but whether under what condition it can be, whether penalty can be reduced. Upon the condition that it is a sick establishment, that is the finding, that is a sick establishment which has been declared sick. Not before that. It can, if there is an error, then that can be looked into it. If there is an error in this 14B proceeding, that can be looked in. Tribunal cannot reduce the penalty. This power is vested on the central board only. This is statutory.
Then what is the role of the tribunal, tribunal?
Tribunal can
If it cannot do
lawsuits-
anything, if it cannot modify an order, then what is it supposed to do?
My lord, the tribunal has come to a finding that has ultimately held that it may be reduced. But on what condition? The Supreme Court has
I
held.
think, Supreme Court has held one. Let us see the Supreme Court judgment.
I don't see, come to paragraph 29.
Yes.
Yes, I'll read paragraph 29. below. From the aforesaid decisions following principles category, the authority under 14B has to apply its mind to the facts of the case and relies focus notice and pass reason order after following the principle of naturality, giving reasonable opportunity of being heard. Regional Provision Fund Commission usually takes into consideration the number of defaults, period of delay, the frequency of the default, and the amount involved. Default on the part of the employer based on the fee of power cut, financial problems relating to other indebtedness, delay in realization amount paid by check and draft cannot be justifiable ground for employer to escape liability. There is no period of limitation prescribed in the legislature for initiating the action of recovery of damages under the 346. Fact that the proceedings are initiated or demand for damages is made after several years cannot be established ground for drawing inference. Waiver of that employer lulls into a belief that no proceeding under 14B would take place. Mere delay in initiating proceeding 14B cannot be a prejudice to the strength. Would amount to employer monies of his own purpose or for the business, especially when there is no additional provision for charging interest. However, the employer can claim prejudice if there is proof that the period between the delay and initiation of the action under 14B is changed to his position to detriment in such extent that the recovery of such made large extent years prejudice is irreversible nature. He might also claim prejudice upon proof of loss of all the relevant records also available to us. Now the irretrievable. Now, my lord, there is another decision, my lord, to kindly see.
Where does it say here? That the tribunal cannot.
No, no, what the Supreme Court has held, my lord. What the Supreme Court has said, there are cases that there's some financial difficulty. The appellate tribunal has also that financial difficulty. But this cannot be a ground the Supreme Court has said. Financial difficulties cannot be a ground.
That is a different issue. That is a different issue. What you are saying is that this tribunal did not have the authority, did not have the power to pass an order.
So we just
You can, saying that it could not have passed the order on the basis of this fact is a different thing altogether. Maybe your initial,
This is one of the aspects. Tribunal's power, there are two aspects. One is, if the tribunal passes an order, the tribunal has to come to a finding, definite finding, that it is a strict establishment on the basis of material on record, that it is a strict establishment. And that, where is that material before the tribunal that it is a strict establishment to enable them to reduce the penalty? That has to be considered. That has to be considered. That has not been considered by the tribunal. That is my subject. Tribunal must come to a finding that it is a strict establishment. It is a statutorily provided for it. So unless the tribunal come to a definite on the objective satisfaction, that on the basis of material available on record that it is sick. Then only the tribunal can pass it. Just on the basis of their submission, the tribunal cannot hold that it is sick as submission.
So you are changing your submission now. Now,
things.
earlier your submission was
No,
the
two-fold
tribunal could not pass such an order
No.
as per the law. Now you're saying it can pass an order, but it has to
No,
make
no,
a finding
that
that
is
it
my
is.
alternative submission, but in my plea, in my writ petition also I have taken two pleas. Alternative, one, tribunal has no, well, it is the central board normally, and they have made an application before the government of India to reduce. After making this application, they have approved. They have annexed, but I have annexed those applications.
Yes, where is that? Where is the tribunal order?
Tribunal order, my lord, can come. Page 90.
Where is the operative portion?
Operative question, my lord.
The findings, where is the finding?
Paragraph, I mean, 7, paragraph 7. Page 90. This is also pervert.
Paragraph 7, page 19,
95.
95.
Of the repeat. The financial position is given shown in page 94 at the top. At page 7, the paragraph 7 says admittedly respondent passed the improved order on the basis of earlier table. This is wrong. I have shown my lord that it is on the basis of the press table or tabular
I
form.
think we have to go step by step slowly. I think.
Lord,
Not for you.
may I read the whole judgment, my lord? This is 3-page judgment. May I read it?
I think they have gone into the merits here and there.
Yes.
They have to go into the merits of.
Then I got to read this 3-page judgment.
Just read some other time.
Lord,
On the present party, this is the matter. Next week,
next week, yes.
this is the matter. Give it.
Typing at a particular.
My lord, with reference was made, your lord will find the reference at page 52, made by the government of Assam.
No, this one. Page 32.
Yes, this is the notification referring the dispute. Whether the management of Messrs. Lorenzo is justified in terminating the service of the workman also, not if the workman is entitled to do as well. See any other benefits of. Now, my lord, after the reference was made, notices were issued to both the parties. However, the management did not take them. On 9/6,
Notice for what?
for appearing in the labor. Yes. Now, my lord, notices were issued. Management did not get notice. However, the workman was appearing and he was praying for time to file judgment. Then my lord, then 9/6, there was an order passed, 9/6/2014. An order was passed by the court. I'm reading the order, which I have to fact. If the workman side is present, notice.
Where is that page?
No, my lord, it will be there in the report. This is the order sheet of the.
My word.
9/6/14.
Unreadable. 9/6/14.
14. The workman is present. Notice issued to the management side has been returned answered. Issue fresh notice to the management through special message 6/21/6/14 for service.
For service report.
The workman side is present. Notice issued to the management has been returned after service from the management after service. But the management is absent without any step. 6/9/10/9 for WS the party. Now, my lord, on 21/6, the notice returned back. There was no report of the special messenger in the note that it was done. Then, my lord, we'll see the workman was taking time to file the statement. Then suddenly on (22/7), on that day also, the workman side is present, the management is absent. Fixed for taking another date for workman files petition. The workman files petition number so and so for time. Where allowed, case allowed. Case which will proceed ex parte against the man.
Where, which order?
My lord, 22/7/2014. So from 21/6/2014, workman was praying time. The court did not proceed ex parte. Suddenly on 22/7, the court proceeded ex parte, although on that day also the workman prayed for time to file the petition. And the matter went ex parte. An award was. It was communicated to the management, and from there the management comes to know about the award and files an application for setting aside the ex parte.
Yes, sir. So did he file WS, the workman?
Subsequent, after the matter has gone ex parte, the workman files a return. Now, my lord, may come to page 46 of the writ petition, where your lordship will find the copy of the notice. Which was purportedly sent to the special man. So and so. Now, my lord, since this is the certified copy of the notice which we obtained from the labor court, if your lordship goes to the notice, lordship will not find any report in that notice of the special messenger. Who is the special messenger? Who has gone there? He just files this notice which has a seal. And interestingly, my lord will see the seals are superimposed. Lordship will find one seal which has something private, then another seal, then some legible signature. So, my lord, my first humble submission before a lordship is on 21/6/2014. The court did not proceed ex parte, but court records the finding in its order that the service is complete. But from this notice, in absence of any report from the service special messenger, first of all, the special messenger, if he goes there, he will give his name and the report, the time and date on which he served it and upon whom. This is what CPC provides. Now, this was not done. Then when we file an application for vacating the ex parte order, the special messenger was examined by the court, and we also examined one person saying that we did not find any road, get any road. And in that order, Lordship will see how it was vacated. Lordship will find that order which starts from page
Page?
40.
40.
Lordship will come to page 44. Here, the learned trial court has relied on the evidence of the special messenger. So from page 46, the notice, we do not know who is the special messenger is. We do not know who was actually sent by the court.
Okay, so where is
Now, my lord, may come to page 44. EW2. See, Noyan Moni Sharma in his evidence stated that Exhibit A is the copy of the notice dated 9/6/40. He carried Exhibit A as the address mentioned therein and served the notice to the management. They put seal and signature therein. A1 is the seal of the management. On being served with the notice, they put wrong seal therein. When I saw it, they put the right seal.
where are you reading?
Page 44 of the writ petition.
Yes, last
Second paragraph from the top. Finding the seal, I returned with the received copy and submitted the same in the next paragraph is his cross-examination. In his cross-examination, he stated that he forgot the date when he went to serve the notice, which is very important. By process server must know when the notice was served. When did he actually go? The order dated 9/6/14, he was specifically deputed for serving the notice on the management. He forgot whether the place when he served the notice was office or godown. The other seal exhibit A1, the word private limited is there, but in the next seal does not show the word private. He did not know the difference between so and so and so. He did not know why there were two seals. Lastly, my lord, he did not submit any report after serving them. So, my lord, it is an admitted fact that the process server or the special messenger did not submit any report of service. So here,
Yes, this evidence was taken in where? In the order 9 rule 13. What
my
is it?
lord, this evidence was taken when we filed an application for setting aside that ex parte.
So order 9 rule 13 application.
But it was not an ordinance rule 13 because in the labor code, CPC is not followed, spirit of CPC. So this is an application which was registered as a miscellaneous application and this
To set
evidence
aside
was
the ex parte order.
taken.
So there's the evidence of taking.
Then they, so my submission before Lordship at the first instance, the record shows the process server did not give any report of service. So the question is whether the labor code at that point of time was justified in proceeding ex parte in absence of any report from the process. Because he did not have any report. So this is a subsequent act. So on that day, my lord, on 9/21/6, he finds some records and passes an order that has returned after service. But where is the report of the special master? Order of 9/21/6/2014. And my lord may also have a look at the order of no. My lord, 21/6 says the notice has come back after serving. 21/6. After service. So, my lord, this after service, there was no service report of the special master. So he records the finding that it passes an order after service. But he did not proceed ex parte then. He went some few days passed and then on 22/7, the order was passed to proceed ex parte against the man. So, and that day also, there was nothing in the record of the court that the service from the special messenger had given his service. It is subsequently when we file this application, this evidence came. And if your lordship, even then in the evidence, lordship will see the special messenger specifically stated that he did not know when did he go there. Now, if your lordship for a moment considers order 5 rule 18 CPC, order 5 rule 18 CPC provides that the passenger or the process server should give a report wherein he should specifically state on which day and at what time he had gone there. Order 5 rule 18. That report is a must. He will specifically say at what time, on which date, and upon whom he had served the note. So, my lord, here it has gone experted. So, my respectful submission, the labor court was wrong at that point of time in proceeding expert. Another fact which I'd like to draw your lordship's attention to, my lord may have a look at the industrial dispute rule, central rule. Now, my lord, under the central rule, if a reference is made, then it is for the party which has raised the dispute to file a statement of claim, that is the written statement. It is only after the written statement is filed by the party raising the dispute, the other side will reply. So, my lord, when the matter had gone ex parte, the workman who had raised the dispute had not even filed the written statement. So, my lord, the urgent lordship may have a look at Rule 10B. One, while referring an industrial dispute for adjudication to a labor court, tribunal, or national tribunal, the central government shall direct the party raising the dispute. My lord, if it is a referring authority, if it is the central government, it's the central government, and if it is a state government, then central will mean state. Shall direct the party raising the dispute to file statement of claim, complete with relevant documents, list of reference and witnesses with the labor court, tribunal, and national tribunal with 15 days of the receipt of the order of reference, and also forward a copy of such statement to each party of the opposite parties involved in the dispute. The labor court, next 2, the labor court, tribunal, national, after ascertaining that the copies of statement of claim are furnished to the other side by party raising the dispute, shall fix the first hearing on a date not beyond 1 month. Then it goes, where the labor court, tribunal, as the case may be, finds that the party raising the dispute, though director did not forward the copy of the statement of claim to the opposite party or parties, it shall give direction to the opposite party to furnish the copy of the statement to the opposite party, and for the said purpose and for any other sufficient cause, extend the time for filing. So, my lord, it is after the written statement is filed by the party raising the dispute, the management, the employer, the other party gets the opportunity to file their reply. And against that, he has the liberty to file a copy. So, the question which requires an examination by a lordship is whether on that day, that is on 22/7/2014, when the learned labor court had decided to proceed ex parte, was any written statement filed by the workman. So, till then, my lord, there was no written statement filed by the workman.
No, the statement of claims will be filed by them. Then
Yes,
you will file written statement.
My lord,
Not
yes,
reply.
statement of claim. Normally, my lord, in the labor court, that is why the order says labor court, both parties files their written. This statement of claim is considered as written statement.
No, it's basically a statement of claim that what to make, then you will file your written statement.
So if this order goes, if your lordship goes to the order state up from the date of issuance of
So
the
that has to be read as statement of claim.
statement of claim, it is illustrated or written. So on that day, workman did not file the written. So my respectful submission before lordship is that order of the labor proceed ex parte was expressly wrong, illegal, because we did not have the materials to form an opinion that the service is complete as there was no service. Second argument is,
Third argument.
no, second on the merit. even assuming everything goes against me, labor court was right in proceeding ex parte against me, then also whether under the facts and circumstances, the award is legally sustainable or not. Now, the award starts on page 20. Before I take your lordship to the award, I would like to urge upon your lordship is the issue was the case of the workman is that he was engaged by the writ petitioner management. He worked for some time, then he was not paid.
Was it a tea garden?
No, man. It is a transport company.
Transport company.
Yeah. Roadway. So the case of the workman is that he was engaged, appointed by the or engaged by the management. He worked, so he was receiving some salary. Then subsequently, at some point of time, he was or the management stopped paying him. Then it continued when he questioned the management and asked for payment, he was removed from service. So, my lord, in this context, what was the first requirement to be established in the proceeding is that whether he was engaged or appointed or not, and on what day he was removed, and whether he was getting any salary during that period of engagement. The only document which the lower court has relied to pass that order will be, which your lordship will find at page 40. This is marked as Exhibit 1. This is the money receipt of South Assam Roadways. Now, what does it say? Received with thanks from Messrs. HPC, CPM, so, sum of rupees so, on such a. Now, this document has been construed by the Labour Court to be an order by which payment of such and such amount was given to the workman by the employer. So, that was taken as an order of his engagement, circumstances of his engagement and continuation in service. And then, since he was disengaged, so it continued. I am drawing your lordship attention to that part. Lordship may come to page 29, paragraph 6. My lord, it is a matter of record that there was no order exhibited by the workman to show his engagement or disengage. Now, my lord may come to paragraph 6. I have perused the evidence of WW1 and gone through the documents submitted by the petitioner work. Exhibit 1, that is the one which your lordship has just now seen at page 48. So that he has received so such and such amount by bill number so from management of South Assam Roadway. The petitioner evidence has clearly stated that since 85 till the date of termination, he was working with the management situated at Lopra, but the management without assigning any reason and without complying with the provisions of industrial terminated. So, my lord, by any stretch of imagination, that exhibit 1, that page 48 document does not show that the management has paid anything to the workman. The name of the workman is Lalan Chaudhary. And my lord, this is a money receipt which shows that the South Assam Roadways has given this money receipt to another company, that is HPC Panchgram, for receiving a sum of rupees so and so. So, my lord,
So this has been received by you, in fact.
no, yeah, no,
Yeah.
this is my company
Yeah.
giving a money receipt.
Correct.
Yes,
You give
my
a
company receiving some
means
money from HPC.
you have received the money.
I have received HPC, money from HPC for some work. I am a transporter for any reason we do not know. This is not, but these documents, by any state of imagination, can this document be construed to be something which my company is paying wages to the concerned worker? To reflect three things:
that he was an employee under me, he was receiving wages, and then he was resigning. So, my lord, from the evidence pleadings, there is nothing on record to show that he was an employee under me. Now, my lord, first thing under the Industrial Disputes Act, a reference is indicated. What is an industrial dispute? When there is a difference between employer and workman, there has to be a difference between employer and workman. Then it will be referred. So, first requirement to establish in a case where one claims is that whether he is a workman. So, to be a workman, if your lordship comes to section 2S of that act, it defines workman. If your lordship comes to 2S of the act, it defines the workman. Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, field, technical operation, clerical or supervisory. So the basic thing is that he has to be employed. So in this case, the claim of the work respondent number 2 is that he is an employee under the management of the petitioner company. So minimum thing that ought to have been done or required from the to support his case is that he is employed on such and such. There is no order in case. Even no evidence of, if I take it beyond that, if there was no order of employment, then maybe his co-workers could have come and said before the court that he was working with me, with the proof that the person tendering that evidence is an employee. No evidence to show that he was employed. So, and there is no evidence to show that he was terminated. And if your lordship comes to section 2RR, it says wages. Wages means all remuneration capable of being expressed in terms of money, which would, if the terms of employment expressed or implied were fulfilled, be payable to a workman in respect of his employment or of work done in such employment and include. So his claim is wages. So to get wages, first thing he requires is, first requirement is that he has to establish his employment, then his wages, what was his wages, and then terminated. Now, in this entire chain, only document which was taken into consideration is Exhibit 1, page 48 document. And from that document, the learned court has come to a conclusion that he is an employee under the management, he was receiving wages, and he was illegally removed, so he should be reinstated with backward.
Okay, now I think I've heard you.
So my twofold argument, ex parte order was bad at that time. Yes, he was engaged, and there is no evidence on it. So my respectful submission is that even if the matter proceeds ex parte, the most important thing that the person raising the dispute will have to establish his claim by way of forging evidence.
Okay. Yes, thank you. First of all, where is the evidence to show that notice was served upon them? At the time, they were declared, the case was declared ex parte the petition.
This is the summary.
Yes.
This was tendered to them, and their personnel has put the seal as signature. And the without seal specifically say South Assam Roadways Limited. Now they have come with a petition stating that this is not our chief. This is not our chief. What he has stated in 244. At page 43. Very good.
Yes, sir.
In his cross examination, he stated that he has not strictly copy of the letter from 2020. In his cross examination, he submitted that in his petition, he did not write about the workman, nor being his employee, nor or about the workman being not returned with it, or about back wages being paid. He did not think that his still is exhibit 3 belong to them. Their inquiry revealed he has not written about it to his higher authority, or he has also not filed FIR SPS. He has not brought his office seal for comparison. 2 persons worked in his office, but he did not mention their names in his evidence. To work of other company is also conducted in his office. There may be other seals of such other companies. In his cross examination, he stated that he is the director of the company since 10 to 15 years. He did not know if they chief in the office. His main contention was that the seal is mine. If it is not mine, then he knows that somebody has done some fraud to him. So why he did not file any FIR? Why he did not inform the competent authority that my seal is being used?
He did not know because it's not his seal.
Now, after coming to know about this, when he has filed, at that time he could have done. At that time he could have done.
Okay.
And he did not bring his main seal to compare that this is my seal.
Okay. Leaving that aside, what about order 5 rule 18?
Yes, Lord. But what he has below deposed that I have passed through that. Or not he has deposed me, Lord.
That is not the issue. That is after the application and the order 9 rules are
Yes.
that is subsequent.
Yes,
I am saying
yes,
on the day when the petitioners were declared, when the suit was declared to proceed ex parte against the petitioners.
Yes.
On that day, there was no service report of the process server.
as per order 5 rule 9. When it is delivery of summons by court. But order 5 rule 9 does not speak about any report. Better on.
Order 5 Rule 9 might not speak about a report. But what about Order 5 Rule 18? What does it say? What is the role? What is the requirement?
In this case, I have to go to the. Wait together.
You see, what we can do is this basically. We'll set it aside. We say we'll remand it back.
Because day after tomorrow, I come back.
No,
Day after.
I don't have time, Mr. Council. Day after tomorrow.
Only on this point I shall pull because. I'm not-
Okay, for leaving this side, this case. What about the issue of the basis for the tribunal coming to a finding that you are an employee of the petition?
There was no denial without a fault.
Naturally, there's no denial because the ex parte actually went.
Yes, that is right.
But what is the basis for the court to come to a decision? Page 48. And for page 48 is not a money receipt issued by you, money receipt regarding payment of money to you. It is payment of money received by the petitioner from somebody else. So it has nothing to do with you.
So day after tomorrow, only one day. Day after.
Day after tomorrow, you have to follow me to, you have to follow me by air somewhere. I will come only for 5, I will come maybe for some time. Okay, that's fine.
Next Monday, Tuesday, anything.
Heard, Mr. S. Chakrabarti, land counsel for the petition. Also heard, Mr. S.
Sahu,
Sahu for the
respondent number 2.
point number. The petitioner bracket management has put to challenge the impugned award dated 31/12/2014 passed by the Learned Labour Court Guwahati in reference case number 2 of 2014. This is the impugned ex parte award case on 2 grounds. On 2 grounds. So firstly, on the ground that the Learned Labour Court has
My lord, we have challenged two orders. One, the award as well as the order rejecting them.
firstly on the ground that the Learned Labour Court has issued order dated 22/7/2014 directing that the reference case number 2 of 2014 would proceed ex parte, the petition. Without any service report being made by the process server. No, without there being any notice being received by the petitioner. And without there being any returns being stated in the summons, endorsing the time and manner of service of the notice, of the alleged notice, in terms of Order 5, Rule 18, CP. The impugned award has also been, secondly, on the ground that there is no proof that the petition, that the respondent is a workman employed by the petitioner. Inasmuch as the money received dated 4/8/1997, which has been exhibited as Exhibit 1, is not proof of payment of money to the petitioner, to the respondent, by the respondent number 2, by the petition. Ah. Next paragraph. The petitioner has also put to challenge the order dated 30/4/2016 passed by the Learned Labour Court Guwahati in Miss Case number 1 of 2015, which was in relation to an application submitted by the petitioner for setting aside the ex parte order, ex parte award dated 31/12/2014, passed in reference case number 2 of 2000. Next one. The petitioner found that the Learned Labour Court had directed that reference case number reference case number should be proceeded ex parte against the petitioner by order dated 22/7/2014. When there was no service report made by the process server in terms of Order 5, Rule 18. As such, there was no basis for the learned trial court to have decided that notice had been served upon the petition. Next. The petitioner's counsel also submits that The respondent number two had submitted his written statement, bracket, statement of claim, only on
8/8/2014.
8/8/2014. That is after the case was directed to be proceeded as part of the petition. He submits that the he submits that it is only after a statement of claim is submitted by the respondent number two, who is the party raising the dispute, that the respondent number, that the petitioner is to file a written statement against the statement of claim. However, the petitioner has been proceeded ex parte even before a statement of claim has been submitted by the respondent number. So he submits that the above, he submits that the filing of a statement of claim and the subsequent filing of a written statement against the statement of claim has to be done in terms of Rule 10B of the Industrial Dispute Bracket Central Rules 1967. Here and after refer to the 1967. The counsel for the counsel for the petitioner for the subject that the impugned award passed by the learned labor court accept has come to a finding that the respondent number two was a workman engaged by the petitioner on the basis of Exhibit 1, which shows that the respondent number two had received 1,37,684 from the petitioner. However, Exhibit 1 is not a money receipt showing payment of money to the respondent number two, but is actually a money receipt issued by the petitioner for receipt of money from MS HPC / CPM Panchgram bracket SM. I can see. Which item is Tara now? Next time. The petitioner counsel. Yes, Tara. Petitioner counsel submit that there is no evidence to show that the petitioner was that the respondent number 2 was engaged by the petitioner or that he had been or that his service has been terminated by the petitioner. That's all I think. Anything else? I think that's all. We accordingly praise that the Impune Award dated 31/12/2014, passed in reference case number 2 of 2014, and the order dated order dated 30/4/2016, passed in miss case number 1 of 2015 by the Learned Labor Court 50. Actually, one more thing you just said. The counsel for the petitioner further submits that at the time of pendency of miss case number 1 of 2015, DW2 Sri Nayan Moni Sharma in his first examination stated that he did not submit any report after serving the notice dated 9/6/2014 to the petitioner. Correct? The petitioner. Let me put that, huh? Next para. Mr. S. Sahu, Learned Counsel for the respondent number 2. Wait for time. Wait for time. Mr. According on the prayer of Mr. S. Sahu, list the matter on. You can do it next week. I won't be here. Some others can do it. I'll be.
Keep it part of, before your lordship.
You can do it next week. What?
My lord, your lordship may keep it part of, before your lord.
You can do it next week before somebody also. Everything is there.
Again, I have to.
Okay, accordingly, list this matter on where? For end of this month, I don't. No, next time we've got that work. No, lot of work. Yeah, actually a small issue. Actually.
It is almost done, my lordship has recorded everything.
Okay, list the matter on Third,
Third, I know, in this November.
when, November,
No.
28, that's right. 20, as partners. Right. Going to, he wants time.
Actually, I have not prepared into merit itself. Only I was
Okay.
on this part.
But we should be ready for everything.
Yeah.
Item 35.
Matter relating to one tenancy permit, extension
Huh?
of tenancy permit.
Uh,
Under a Dum
Tenancy. Is that bench 5 matter? Bench 5.
market space.
Market space.
Tenant.
Look, I've got no problem doing it, but I don't want to do a case which I not supposed to do.
SS Roy was or town.
My God. This is a 2017 matter.
Really extension to some.
So there you've got a chamber. The chamber behind you was allotted to you, according to you. Was it by way of a written allotment order?
Yes.
And that now has been allotted to the respondent number 5. Yeah, the respondent number 5.
I'm a correspondent.
Town committee has produced the record. SS Roy was on the last board. As reflected by the last board.
You were supposed to deposit some amount for the extension. Did you submit? Did you submit that amount?
No, my lord, I submitted for extension. Thereafter, I was willing to submit, but as my lord knows how this town committee works for.
I have got no idea. I've got no idea how it works.
That as per the Assam Municipal Act.
No, you were asked to submit an amount for that extension period. You were given that extension in 2009.
And that was reduced.
The area was reduced.
Yeah.
But
Thereafter,
you did not submit your money. Then how
I
could-
was willing, but prior to that, it was allotted to.
allotted to the respondent number 5 when?
In the year 2000. It is there.
After 7 years.
Oh, it was not.
But it is not a ready-made one. It is my opinion. So the first thing is that I had to.
So for 7 years, you did not pay anything.
To that extent, that is correct. But the problem is there. The problem is there, my lord. First thing is I was willing. So they did not take any or resolution. Actually, what would happen in taking any such kind of decision, the annual meeting was to be that subject. Thereafter, one resolution is taken by the president with support of all the members. That was not done. And behind there it was given to that person and one document, that final resolution, when I made an RTI to give me all those documents, that resolution was not provided to me. But subsequently, when record was called for, one resolution is there. And in that resolution, only the signature of president is. I have checked it.
For him, for you. No, for in which case? For allotment to him or
Yeah.
for allotment? Only president signature.
Member signature or
Not there.
and
So records are necessary.
they have not submitted those records with their affidavit in reply. I previously
You are appearing,
SS Roy was.
so we cannot dispose of without him. I think records will be necessary. Huh? Who is the council now?
SS Roy. Which SS?
It's, cannot be missed.
That information was not also not.
That is to be paid annually.
One time amount, it was 1,05,000.
Not paid, actually, this should be disposed of, a small issue, very small issue.
Kindly come to page 31.
No, because, no, I'm more than that. You see, I'm to, dispose of only item format, or bench format. If this is a bench five matter, if the bench five matter, then I don't think it's proper for me to deal with it. If unknowingly I did it, that's a different thing. But since I've been told now that the bench five, then. Correct. Mr.
DK Nath.
D.K.
Nath.
Nath appears for the petition, while Mr.
That's all.
S. Khan appears for the respondent number 5. No one appears for the respondents number 1 to 4. What? Okay, no one appears. Mr. K. Gogoi appears for respondent number 1. 1 and 4. Even Mr. S. S. Roy had earlier appeared for respondent number 2 and 3. However, he is not present today. It appears that the official reports are required for disposal of the case. Accordingly, let this matter before the appropriate bench. When?
Can it be on 28th November to it? It's a Thursday.
On 20th and 11th. On which date Mr. S. Roy should produce the report? The registry should verify whether the matter pertains to bench 4 or bench 5 and list it before the appropriate.
Okay.